చూసి వెతికి
అదేంటి ఇన్స్ట్రుమెంట్ అది?
అవును సార్. మనం ఇప్పుడు
చేసేది లైవ్కి వెళ్ళడానికి అది కావాలా?
లైవ్ వెళ్ళిపోయింది.
ఓహో, వెళ్ళిపోయిందా?
స్ట్రీమ్ ఈజ్ ఎక్సలెంట్.
నేను చూస్తాను, ఇక్కడ పెట్టాక మనం లింక్
నేను తెచ్చుకుంటాను.
నేను గ్రూప్లన్నీ షేర్ చేస్తాను మన పిల్లలకి.
సార్
రానవద్దులు సిగ్నల్స్ తక్కువ. అదే లింక్ మారుతుంది.
లింక్ ఒకసారి చూడండి సార్. లింక్ ఒకసారి చూడండి సార్. ఇది మీ ఛానల్లోకి వెళ్తే వచ్చేసి సార్.
ఛానల్లో లింక్ పెట్టారు, మరి పిల్లలు అమ్మాయి లింక్ షేర్ చేయమంది, అది తిరుగుతూ ఉంది.
ఒకసారి ఛానల్కి వెళ్ళిపోండి.
యూట్యూబ్కి వెళ్ళినా
లేదండి,
అది 34 minutes ఎగో సార్. అది
అదే
34 minutes ఎగో. ఇప్పుడు లింక్ వస్తుందా?
యూట్యూబ్లో ఏం వస్తలే.
చిన్న
అసలే కాలేజీ ఆన్లైన్ చూస్తున్నాను.
ఇట్లా పెట్టాలి.
ఏం కొట్టాలి? కాపీ ఏం కొట్టాలి
సార్? కన్జ్యూమర్స్.
అదే మరి అందరికీ తెలియదు కదా,
మళ్ళీ పంపించాలి సార్.
కన్జ్యూమర్స్ గైడెన్స్ సొసైటీ లింకా
ఛానల్ సార్.
కన్జ్యూమర్ గైడెన్స్ సొసైటీ. అచ్చా, ఇది పంపించాలంటే మనం
ఎక్కడి నుంచి పంపించాలి?
ఎట్లా పంపించాలి? పిల్లలకు పంపాలంటే ఎట్లా పంపాలి దీన్ని? ఓకే, పెట్టి పంపించేస్తాను.
ఇది బలవంతం ఏం లేదు సార్. ఎవరన్నా సబ్స్క్రైబ్ చేసుకున్నట్టు సబ్స్క్రైబ్ చేసుకోమన్నాడు
పిల్లలు.
and all the student competitors. We welcome you all to the third National Legal Fest, Siddhartha 2024. First of all, I would like to congratulate both the teams for getting selected into the final round. The presentation for the final round shall consist 40 minutes of time, out of which no mooter shall exceed speaking for more than 30 minutes. 5 minutes will be allotted for the rebuttals. And time admonitions shall be given by the court marshals to the use of placards and the ring of the bell for the last 10 minutes, 5 minutes and 2 minutes respectively.
Initial for 30 minutes.
40 minutes.
Initial address.
40.
Initial address is for 40 minutes.
No sir, the whole argument, the time is for whole argument.
Initial address is for how many minutes? You said 30 minutes, that's what I understand. Is it so or not? How many minutes should
40 minutes amma.
40 minutes.
Total.
Yes,
40.
Total 40.
Each 40 each. 40 each 40.
Sir, each consists of two mooters, mooter 1, mooter 2 and the third member is the researcher. Mooter 1 shall speak for 20 minutes, mooter 2 shall speak for 20 minutes. As for the convenience of advancing their arguments, they can share the time according to their wish, but no mooter shall exceed speaking for more than 30 minutes.
They have to show the time.
Yes sir, the time admonitions shall be given by the court marshals for the last 10 minutes, 5 minutes and 2 minutes respectively.
Motor 1 and 2. Another respondent, who is the respondent? These are respondents. There are
These
appellants.
courts fuller.
There are appellants and there are respondents.
Team Benson is going to argue on behalf of the appellant side and Team Fuller is going to argue on behalf of the respondent.
There are two motors. One research. Who is the researcher here? Yes. What is the team code? Bentham and Fuller.
Yes, sir.
What is the time to start?
As per the few seconds.
With your kind permission, I would like to invite Team Bentham to present their arguments on behalf of the appellant side. Team Bentham, please start your proceeding.
Greetings to the Honorable Bench. The Council seeks permission to address the things collectively as Your Lordship. Much obliged, Your Lordship. Your Lordship, the Council is appearing in the matter of Tech with Human Face versus Union of Indica, appearing on behalf of the appellants, and we have invoked an Article 136 of Constitution of Indica before this Honorable Moot Court, Your Lordship. Your Lordship, the Council one that is needed will be dealing with the first issue, and I will be utilizing 20 minutes of this court's valuable time.
Motor.
Council number
First you have to represent I am not one. Otherwise I don't understand.
Certainly.
Oh.
Your Lordship, I Moot 1 will be addressing the first issue, that is with respect to the maintainability of this particular appeal, and my co-counsel, that is Moot number 2, will be addressing the second and third issues respectively, that deal with the power and authority of this honorable court to intervene in the legislative matters, and also the urgent pressing need in this particular matter, Your Lordship. And if Your Lordships may permit, could I make use of this?
Please.
Mic, Your Lordship? Just a minute, I had to.
Please. You are speaking in a speaker.
Your Lordship, they said that I'm supposed
Live,
to do this
we are-
because they are
sir,
giving me live.
we are giving-
Need it, the speaker.
తీసే
This is the problem with the speaker.
ఓకే తీసేయాలి
Want to address that way, all right. When I feel more comfortable if you address us straight away instead of a speaker and all that.
You want to record it?
No, sir, we are giving live to the seminar hall. Other students are waiting there.
All right.
Sir,
You use the-
for the benefit of other students, sir.
You do it. And otherwise perhaps. Okay. Other.
అయినా లైట్గా సౌండ్
సౌండ్ తగ్గించారా?
Hello. Okay. With your lordship's permission, may proceed with the pleadings, your lordship. Your lordship, the council seeks permission for a brief statement of facts. Your lordship, in the present matter, Zenith Tech is a company and they have come up with an advanced generative AI model which can conceive, design, plan, visualize and execute tasks independently, your lordship. And there is a NGO in this particular country called Tech with Human Face, which is a NGO initiated by altruistic scientists of this country, and they had approached the Supreme Court of Indica seeking a direction to the policymakers to make sure that there is a robust regulatory mechanism concerning Gen AI and allied technologies, or in the alternative to issue interim guidelines until the legislature intervenes. However, the Supreme Court of Indica dismissed the petition, saying that there is no public interest involved in this matter, and also that this particular matter falls squarely within the legislative domain and not within the domain of judicial. And before proceeding with this particular petition, the appellants had also approached government and had made several recommendations. However, the government in its correspondence stated that this particular technology is still at a nascent stage and bureaucratic control would be sufficient at this particular point of time, and also since this is a cross-boundary issue, an international framework would be better suited to address the concerns that are being raised by you. Your lordship, aggrieved by the dismissal of the petition subsequently in the Supreme Court of Indica, the appellants have approached the Honorable Moot Court of Indica in this particular matter, and as per the factual matrix and the clarifications provided to us, the Moot Court of Indica here acts as the apex court of the country, which in our case makes the Supreme Court equivalent to the High Court in the existing Indian situation, your lordship. If your lordship may permit, I would like to proceed with the pleadings, that is with respect to the first issue, your lordship. Much obliged, your lordship. Your lordship, the first issue here deals with whether this appeal is maintainable before this Honorable Moot Court or not. Your lordship, I would like to submit that the present appeal is indeed maintainable, and I would like to substantiate the same in a fourfold manner. Firstly, I would be establishing that the appellant have requisite locus standi, and secondly, that the matter involves a substantial question of law, and thirdly, that there is an exceptional and special circumstance in this particular matter, and lastly and finally, that the Honorable Court must intervene to ensure that the complete justice is secured under Article 142 as well, your lordship. Your lordship, coming to the first limb of my argument, that is with respect to locus standi. Your lordship, as I mentioned earlier, here Tech with Human Face is an NGO initiated by altruistic scientists. This is the only sentence that is being given to us in the factual matters. However, considering the entire context, your lordship, Tech with Human Face deals with any intersection, any sort of intersection between tech and humans, your lordship. Altruistic scientist, your lordship, altruism is a character wherein it is by definition selfless in nature, your lordship. When we say altruism is a trait wherein you think about others, even if it is at the cost of your own interest, your lordship. Your lordship, when it comes to the aspect of locus standi is nothing but the right of being heard in the Honorable Court. And also, as the Honorable Court has widened the definition of locus standi in several cases, any member of the public or any public spirited organization can bring a petition before this Honorable Court if it is bona fide and if it is in the interest of the public, your lordship. Your lordship, Tech with Human Face is an NGO that is initiated by scientists. Now, scientists, your lordship, by their very nature, they do not like regulation. Scientists are someone who love freedom, who love to experiment, who love to innovate, who love to find any sort of new dimensions that can be found out in the existing system. However, the very fact that scientists have approached this Honorable Court seeking a regulation for generative AI and allied technologies clearly proves the point that here the petitioners the appellants are acting not in the self-interest, instead in the public interest, your lordship, and thereby I contend that we have enough requisite locus standi to appear before this Honorable Court. And I'll also like to substantiate that with the other limbs, that is substantial question of law and exceptional and special circumstances, your lordship. Now we have invoked Article 136. We do understand that this is a discretionary power of this Honorable Court. However, your lordship, in the famous case of Chunilal V. Mehta versus Century SPG and Manufacturing Company Limited, the Supreme Court had laid down a ratio decision that in order to decide whether there is a substantial question of law involved in the matter, we need to understand whether there is a matter of general public importance or whether the interest of parties is being directly and substantially affected, Your Lordship. And also, if it is being affected, then whether there is a need for the alternative view, whether the matter is already settled by the Honorable Court. Your Lordship, now coming to the first aspect, that is general public importance. This particular phrase has not been defined anywhere, Your Lordship. And in the light of this, it is very necessary for us to understand that in the interest of public, that is, the general public importance must be construed in the light of public interest, Your Lordship. But public interest is also not defined anywhere, Your Lordship. However, I would like to submit a document to the Honorable Court, if you may peruse the same. In fact, even in our written submissions, paragraph number 6, if you may notice, we have included the same details entirely, Your Lordship. Your Lordship, here, public interest is the general welfare of the public that warrants the recognition and protection, Your Lordship, recognition as well as protection, and something in which public as a whole has a stake, especially an interest that justifies governmental regulation. Further, Your Lordship, immediately below that, there is a public interest exception. It is a principle that an appellate court may consider and decide a moot case, although such decisions are generally prohibited if the case involves question of considerable public importance. Secondly, question is likely to arise in the future and question has evaded appellate review. Your Lordship, the present factual matrix clearly shows that generative AI and allied technologies is something that ticks all these check marks, Your Lordship. Firstly, this is a technology that can be disruptive, that can be beneficial. However, recognition is what is important, Your Lordship. In the present legal framework, there is no recognition to this particular technology to begin with. That is, there is no acknowledgement that there is indeed a technology which can actually act in a disruptive manner, Your Lordship. And secondly, Your Lordship, coming to the future questions, Your Lordship, this particular technology is so uncertain that it can raise so many questions, it can intervene.
1 minute. I'm not able to understand. You are supporting the claim for the intervention of the court, or to have rules framed, or do you say that no rules need to be framed at this stage because international forum will decide and all that? Are you for that, or you for that? I'm not able to understand. It's something like this. Long ago, when I heard a judge, after arguments were addressed for about 1.5 hours, he said, are you for the plaintiff or for the defendant? I'm not able to understand what you are saying. Which side are you?
Apologies, Your Lordship. I would like to make my stance clear. Here we are representing appellants and we are seeking
Who is
for the NGO, Your Lordship. The NGO is seeking for the NGO is seeking for the regulation, Your Lordship, and we are establishing public.
Okay.
Much obliged, Your Lordship. Your Lordship, as I was mentioning earlier, the question of public importance. Here, the generative AI and allied technology is such a technology that it intervenes in all aspects of our life, Your Lordship. It is not with respect to one particular issue. If I were to give you one very good example from our own fraternity, Your Lordship, even the judiciary, very recently in the case of Zakir Hussain versus State of Manipur, it's a 2024 case, Your Lordship. Here, the Manipur High Court Judge, Justice A. Guneshwar Sharma, made use of GPT 3.5 to understand certain aspects of the case, Your Lordship. We have highlighted it in the paragraph number 15 of our written submissions as well. What we are trying to establish here is that the judiciary is usually the one that is reluctant to inculcate these kind of new technologies, Your Lordship. In fact, judiciary always likes to err on the side of caution. However, if the judiciary itself is making use of such technologies and there is no regulation, let alone regulation, there is no recognition of this particular technology by the regulatory framework, that underscores the very importance that despite Gen AI and allied technology being such an integral part of our life at this particular point of time, there is no law, there is no clarification with respect to the kind of approach that the companies must take, Your Lordship. For instance, if there was an ethical guideline, if there was, now Your Lordship, generative AI as a technology is something that depends on the kind of input that you give. For instance, if I give you a biased input, then that biased input would go in a loop. If I feed you a biased data, that input would be in a circular loop, it would circulate and the machine would learn from the same data, it would produce another output. That biased output will be used to produce another biased output.
For example, AI gives a wrong fake citation. What would be the remedy?
Fake
AI generates a fake citation.
Indeed, Your Lordship.
What would be the remedy?
Your Lordship,
I am searching for a case. AI suggests a fake citations and fake citations. Those are not genuine.
Indeed.
These are fake citations.
Indeed, Your Lordship.
As if we have to use that these are the real citations. How can you address that problem?
Your Lordship, this is also one of our contentions that we are raising. In fact, since we are for the appellants, we are saying that the AI is capable of giving such fake citations. And there is no regulation, there is nothing to say. Now, Your Lordship, fake citation, the aspect of fake citation that you raised is a very pertinent issue. Once again, that fake citation comes from the very fact that the data input has been made in a wrong.
If I search there is no data, it is a fake.
Indeed, Your Lordship, that is also a contention, Your Lordship. There is no transparency, there is no traceability. You cannot trace the output that is being given to you to a particular input. There is no transparency. In fact, the experts call it as a black box problem, Your Lordship, that there is no way you can understand whether this output B came from point A. We do not know the source of this particular output. So the appellants are here arguing that there needs to be a regulation in place so that we can identify this, identify and trace the source. We can identify the kind of input that is being fed so that we can control the output. In which case, that would solve your question of fake citation, Your Lordship, because the input, if it is following all the kind of guidelines that would be set by the regulatory framework, then you would get the appropriate output as well, Your Lordship. And that is also our contention, Your Lordship. As appellants, what we are saying is that generative AI is a beneficial technology as well. However, regulations would not only restrict some of the bad aspects of it, it would actually help the companies to develop their technology in a responsible manner. If there was an ethical, Your Lordship, just to give you an instance, if there was an ethical guideline that a company operating in a high-risk ecosystem, like let's say impacting general public to a very large extent like healthcare or education or something that has to do with a larger set of people. Now, Your Lordship, if they are given higher liability, if they are given higher responsibility, so that whenever you are feeding data, these are the things that you need to follow. These are the kind of checklists that you need to fulfill. These are the kind of representations that you need to make. Your Lordship, there will be accountability, there will be transparency as to who should be held liable and who can be traced to that particular offense. In the present instance, there are no guidelines, Your Lordship. There are no liability fixing mechanism. Here, if at all an AI commits an offense, now Your Lordship, there have been several instances wherein an AI chatbot has made sure that has interacted in such a manner that the person who was interacting with it fell into depression, committed suicide. That suicide case has not happened in India. However, I would like to produce a document which happened in Brazil, Your Lordship. Here what happened was this person was an activist who was interested about the ecology and basically about conserving the environmental interests of the world, Your Lordship. Here, this person in desperation went to AI chatbot and started having conversations with it regarding the future of world and whether there is any possible remedy that could be foreseen to make sure that the environmental interests are not compromised in the near future. However, during the conversations, chatbot basically gave him an answer that no, this is not at all possible, human action will never stop and the world is going to degrade someday or the other day. Your Lordship, what we are saying is that these kind of, this amounts to abatement of suicide kind of behavior, because here, when the person is already in a depressed state of mind and in the kind of world that we live in wherein privacy has been given paramount importance and a person usually is surrounded by no one but himself and his computer. Your Lordship, if a person is going to a chatbot and typing things and asking for answers, and if the companies are developing that chatbot and generative AI in such a way that it can emote, it can basically replicate the emotions that are being conveyed by humans like happiness. Let's say if you give it a text that I would like to know about this, it will say, hi, sure, certainly, I will do it. It is not a machine generated response, Your Lordship. And also if you ask it, how are you, it will say, I'm fine, I am fine, I would like to converse with you. Basically, an AI chatbot will talk to you just like a normal human being, Your Lordship. Now this will invariably develop a connection there, and this will actually lead to any sort of increased chances of suicide, depression, anxiety and all other mental related disorders as well, Your Lordship. Now after that, the company came up with a response that we are going to
instill a particular kind of software which will intimate us whenever the person types something related to self-harm, so that we can redirect it to the relevant authorities. Your Lordship, these kind of regulations need to be in place before such incidents happen, Your Lordship. These are the
What is the recent comment of Honorable Supreme Court about recent comment of Honorable Supreme Court with regard to artificial intelligence? Recent case.
Your Lordship,
Have you come across any citation from any other high court about the validity and authenticity of artificial intelligence recently?
Your Lordship, the present matter deals with generative AI in particular and not AI in general, Your Lordship. And concerning generative AI, the Council is not aware of any precedents that are being set by the Honorable Court or any kind of opinion that was rendered by the Honorable Court, Your Lordship.
There is a recent judgment was reported about the authenticity of artificial intelligence.
Your Lordship,
Okay, no problem.
as I mentioned earlier, the factual matters are very specific to generative AI. Once again, I would like to establish that generative AI is a subset of AI.
There are two things. First, you say that there is a likelihood of commission of suicide. That's an extreme case.
Your Lordship,
You can't take it as the criteria to say that there should be some regulation.
certainly not, Your Lordship.
Secondly, is it not? It's not an easy matter. I personally feel it's not an easy matter to fix the regulations. It takes. You said either the court should frame the temporary regulations, guidelines, or the government should. In whatever way it is done, it takes a long time. What about the interim? It takes a long time to decide all the pros and cons and ultimately to decide whether we should have, okay, let us issue, we should have regulations. What the regulations should be? There, a lot of time is to be taken. Meanwhile, what about the interim period? No use of this artificial intelligence in the UI?
certainly not, Your Lordship. The Council does recognize that Internet is a fundamental right and any subset of Internet is also a fundamental right. However, we are not at all seeking for a banning of generative AI and allied technologies, Your Lordship. In fact, we recognize that there are benefits
On
involved.
the other hand, you said that there should be regulations. What do you mean by that? So till the regulations are created, should it function or not? Suppose you say it may continue to function, let the regulations be framed later. What do you say about what time? If the regulations, you say that unless the regulations are framed, they should not function. What is going to be?
Your Lordship, we mostly fall in the former part of the suggestion that was made by this honorable bench. That is, here we are seeking for two prayers. A, directive to the policy makers to make sure that there is a robust regulatory framework. In the alternative, we have also prayed that the court may issue interim guidelines, Your Lordship. And for the interim guidelines, Your Lordship,
I am not asking. I am saying that it takes a long time even for the court to create interim guidelines. Till then what? What do you say? Till then you want it to stop or do you want it to progress? Go ahead, but interim regulations have to be created by the court. And if so, till what is the period before which interim guidelines are to be fixed? Interim guidelines is not an easy matter to fix interim guidelines in a matter of this nature.
indeed, Your Lordship. Your Lordship, first I would like to highlight that there are reports of Niti Aayog from 2020 itself, wherein they have made some sort of guidelines that would be followed by the regulatory framework, Your Lordship. That would have eased the burden of this honorable court in issuing these interim guidelines, Your Lordship. If I may refer to the document, Your Lordship, just. Your Lordship, here it says a negligence test for damages caused by AI as opposed to strict liability. This involves self-regulation by stakeholders by conducting damage impact assessment in every stage of development of AI and also apportionment of damages so that you can fix the liability based on proportionality of involvement of parties. Your Lordship, here what we are saying is that the government must frame regulatory frameworks that are robust in nature. However, before doing that, the Honorable Court may be pleased to issue interim guidelines that could compel the companies to follow certain ethical standards, Your Lordship. So fixing a certain ethical standard is not a time-consuming procedure, especially in the light of existing legislations in other parts of the world and also in the light of the recommendations that are already being made by the think tanks and the kind of organizations that are already a part of this government, Your Lordship. So, Your Lordship, we, as appellants, we are contending that interim guidelines, the issuance of interim guidelines wouldn't take as much time as the court honorable bench is expecting in this particular matter, as this is not a matter where there is no reference to begin with, Your Lordship. Here there are enough references, enough sources to understand the kind of ethical guidelines that can be set for the companies to follow in the first place, Your Lordship. Once the companies adhere to these sort of ethical guidelines, the other part of the cycle or other part of this particular chain can be regulated in the subsequent manner, Your Lordship. So firstly, we should make sure that the input and the very first stage is being regulated as per the ethical guidelines, Your Lordship. This is the prayer of the appellants in this matter, Your Lordship. Your Lordship, coming to the violation of fundamental rights aspect of this, Your Lordship. Here, first of all, Your Lordship, Article 14, which talks about right to equality, is already being infringed by AI software, Your Lordship. It's not in a distant future. I would like to substantiate the same by stating that here, Your Lordship, firstly, that input that is being fed, as I mentioned earlier, if it is biased, it will give you a biased output. Let's say there are thousands of images out there which depict women in a particular form, wearing a particular cloth. AI will not understand the ethical and moral obligations involved with it. It will give you a output based on whatever is being fed into it. Your Lordship, the bias can be of a caste nature, it could be of religious nature, it could be of a sexual nature, it could be of a gender nature, it could be of any nature. Basically, any sort of bias that you can think of from a human being can be the bias of a generative AI model as well, Your Lordship. Here, as I mentioned earlier, the Article 14, which talks about the right of equality, comes into play because and also the aspect of PIL, that is voice for the voiceless, comes into play, Your Lordship, because here public are already being affected, even though they don't know that they are being conceived in a different notion, Your Lordship. Now, if a person were to use generative AI model to get a certain output, let's say an opinion about a particular tribe in the land of Indica, Your Lordship, generative AI model will give you information based on whatever information is available on the internet regarding that tribe. If there is a biased information, generative AI will not say that this is a biased information, don't take it on its face. Generative AI will basically say that this is the information, please go ahead with it. Your Lordship, and also when it comes to generative AI, there are a lot of things involved. Like generative AI will never say that this is the time limit that is fixed. Your Lordship, these models are trained until a particular time. That is, this model is trained for March 20, 2024. This model is trained for June 20, 2024. Which means until then, they were supervised and trained. However, Your Lordship, the generative AI model does not speak anything about it unless you explicitly ask this question to the generative AI model, Your Lordship. So here, the rights of the public, Your Lordship, with respect to how they are portrayed, with respect to how they are depicted and how they are understood by the others, are also being violated. And also when it comes to the aspect of employment, Your Lordship, now there are a lot of companies and a lot of law firms in our own fraternity who have integrated generative AI model to their employment hiring software, Your Lordship. Here, what happens is they will make sure that there are certain keywords that are noted by this particular model, and if that model sees that keyword, or if that model sees a pattern in your curriculum vitae or in your resume, that will immediately flag that particular CV as not suitable for that particular role, Your Lordship. In this particular matter, Your Lordship, there is no human intervention in here. Generative AI is deciding your fate of employment. Generative AI is deciding your fate of future prospects just merely based on a few keywords and the patterns that were fed to it. Your Lordship, here, what we are contending is that in the absence of ethical guidelines, in the absence of any sort of recognition and regulation by the regulatory framework, this goes to the very basic, that is, right to employment, right to equality, and also, Your Lordship, when it comes to life and livelihood, even that part is included in this particular aspect, Your Lordship, that is with respect to employment and the way they.
Do you support that in the other artificial intelligence can make decisions, and such software will be used lawyers and judges in judiciary? Do you support that the artificial intelligence can make a decision either to write an argument and write an order or judgment? Can it be used in judiciary or not?
Your Lordship,
What do you support or not?
Certainly not, your lordship, certainly not.
Then how are you asking about the appellate side? The appellate, your case was dismissed by the Supreme Court.
Indeed, your lordship.
Because this is not a public interest litigation. Now we have to support. Why artificial intelligence cannot make a decision?
We are supporting
Why
that.
are you arguing now? What is the
We are supporting that decision, your lordship, that artificial intelligence cannot replace the honorable court, your lordship.
Whether artificial intelligence can be used for decision making and to support the argument of a lawyer in the court of law.
Your lordship, and adjudicating a particular case requires not just a mathematical formula or a statistical formula of 1 plus 1 equal to 2, your lordship. Here there are a lot of other factors involved, like a human touch and understanding the facts and context of a case as well, your lordship. When it comes to generative AI, it cannot make the decisions on behalf of you. What generative AI can be made use of is to, let's say, write judgments if it is already decided, if you already have an answer, like a speech to text. If you are saying something, it can write it for you, your lordship. However, it cannot be employed to make decisions on behalf of the judiciary, your
For
lordship.
example, you became a lawyer and appearing before the Honorable High Court.
Indeed, your lordship.
You have to write an argument. When you use artificial intelligence,
If your lordships may kindly
you
repeat.
are appearing before a high court for a case.
Indeed.
You have to submit your argument in written format.
Indeed.
Can you use the artificial intelligence?
Your lordship, firstly, since nowadays everything is written, everything is typed.
You use the artificial intelligence to reject the mark.
Your lordship,
Writing the argument, do you use artificial intelligence to write your argument or not?
it can be employed to write your arguments, your lordship. However, if you already know the arguments, as in artificial intelligence will not give you arguments. It will just write.
You will make a good advocate. You are not answering the questions of the court. You will make a good advocate.
I apologize, your
Don't
lordship.
restrict you. Don't restrict for you. Though you may be right, you must be confident. Yes, it can be used. No, it cannot be used.
Certainly, your lordship.
Intelligence.
Your lordship,
What will you say?
Your lordship, yes, artificial intelligence can be used by advocates while presenting their claims or written statements. However, the council is merely stating that artificial intelligence in this case is not framing your arguments for you. It is merely acting like an assistant who is writing.
Exactly what his lordship has been asking you.
Certainly, your
I
lordship.
am asking you, what is your intention? Now you have answered the question for the first time.
Certainly, your lordship. Your
Confidence is very nice.
Your lordship, and considering the exceptional and special circumstances in this matter, your lordship, there could be no other matter that could fit this particular phrase in its most literal sense, your lordship. No case has arisen before this honorable court that involves generative AI and allied technologies and the regulatory framework regarding it. This is a special circumstance and this is an exceptional circumstance, your lordship, because this is a kind of breakthrough that could define the century, your lordship. Generative AI is not something that intervenes in one aspect of your law, as I mentioned earlier. It deals with the privacy aspect, it deals with the copyright aspect, it deals with the consumer aspect, it deals with all sorts of offenses, the criminal offenses aspect. Basically, it is the kind of technology that has multifaceted nature in itself, and your lordship, a non-recognition and a non-regulation of this sort of technology would cause substantial injury to the public at large, your lordship. And your lordship, this could also threaten the unity and integrity of the nation, your lordship. I would like to substantiate this with a very simple example that would solve all the kind of ambiguity surrounding it, your lordship. Now, if we go back to the time before the advent of internet, let's say there is a riot happening in one remote corner of the country. Now, for that news to reach another part of the country, it has to come through a newspaper or a radio. Basically, there is a time gap, there is a time delay between the reporting of the incident, and also the details would be either expressed through words, or basically you don't have much room for interpretation in that particular matter. You have understood that only through the words that were written or said to you, your lordship. However, with the advent of internet, what happened was that, let's say there is a riot happening in some remote part of the country. Now that video, or a fake and doctored or manipulated video, could reach another part of the country within minutes, your lordship. Now, your lordship, if it may observe, the kind of country that we are living in. It's a diverse country, Your Lordship. It's a diverse country, and whenever there is diversity, there is bound to be a lot of similarities and also a lot of differences, Your Lordship. Now, Your Lordship, when there is a gap, when there is no gap between this information dissemination, and also when it is very easy to manipulate the videos, to manipulate the public opinion, to manipulate the public interest, to manipulate the public emotion, Your Lordship, it leads to public disorder and chaos in the society, Your Lordship. Now, if this particular situation is viewed in the light of generative AI and allied technology, Your Lordship, generative AI and allied technology is such a technology wherein if you give a text that I would like to see a picture of Hitler and Stalin sitting together in a room and shooting a person belonging to a minority sector. Your Lordship, it will generate an image for you and it will give it to you, Your Lordship. Now, there could be no other disruptive and easier way to disseminate your propaganda and make sure that the public are being incited in an instantaneous and also in a bulk manner, Your Lordship. Here, you can generate thousands of images within a day, Your Lordship, and also if you have employed certain people, and if you have basically, Your Lordship, this is not a remote contention. My co-counsel is actually going to substantiate this with the help of a research report that was given to us by the UN-backed think tank, wherein they clearly showed that Al-Qaeda, ISIS, and all the other terror organizations have been using this, have been making use of this to recruit more people to their organization, to make sure that the innocent people are being brainwashed and included in the organization, Your Lordship. So thereby, generative AI is not just a threat, and it also is very closely related to the national security. It is related to the unity and integrity of the nation, Your Lordship. In totality, all I am trying to contend here is that it is a kind of technology that could threaten the existence of individuals at large, Your Lordship. Because here, if you go through the factual matrix, Your Lordship, I would like, just a minute, Your Lordship, I would like to use the factual matrix that are given to us. Your Lordship, if you may kindly peruse the first paragraph, therein it says that the AI, third line, Your Lordship, this AI is endowed with an inbuilt mechanism to conceive, visualize, design, plan and execute tasks independently. Your Lordship, what this means is that if I may illustrate this through an example of ChatGPT, you give a command that I want to write an email. I want to write an email. It will give you the structure of the email. It will give you the format of email. It will give you the kind of words and phrases that you must be using in the email. After that, it will send the email on your behalf. Now, this sending part, Your Lordship, this is very crucial in the light of the public order, Your Lordship, because whenever you are executing tasks from start to finish in an automated manner, that is the easiest way to automated cyber attack and conduct automated propaganda in the country, Your Lordship. Basically, it is making your task so easy that you initiate a procedure and you leave it at that. Everything is taken care of by generative AI and AI technology.
Okay, like ChatGPT, explain your case in 3 lines. Don't argue more. Brief your case in 3 lines.
Your Lordship, our case in 3 lines. I would like a minute.
You are a ChatGPT. Make your case in 3 lines.
Your Lordship, as a human, I would request a minute of time, Your Lordship.
Therefore, I am talking how we have to rely on artificial intelligence. If you go to ChatGPT and ask, present your case in 3 lines, they give data. Likewise, you support it by writing your case in 5 lines.
Certainly, Your Lordship. In the
Try to mention your case in 5 lines.
Certainly, Your Lordship. In the present matter, as the appellants have clearly contended that there is a...
I don't want more argument. I want 5 lines about your case.
Your Lordship, there is a substantial question of law involved in the matter. There is a special and exceptional circumstance in the matter, and there are no regulation, no recognition by the government or any sort of authorities by the country. And also, this is a disruptive technology that could be used for various nefarious activities, Your Lordship, and thereby the appellants are seeking for a direction to the policymakers or in the interim or issue an interim guideline by this honorable court, Your Lordship.
I can explain Ramayana in 2 lines. Rama has taken away Sita. Rama fight with Ravana.
Indeed, Your Lordship.
Rama killed Rama. This is Ramayana. I mentioned in 3 lines. You mentioned your case in 5 lines.
matter involves a substantial question of law. There is a vacuum which is not addressed, and judiciary has the power and authority to address and intervene whenever there is a vacuum present in this particular matter. Your Lordship, in the light of the importance and the grave importance of this particular matter, we are saying that there is a legislative vacuum, and the judiciary has all the power and authority to intervene in this matter and ensure that justice is served to the appellants accordingly, Your Lordship. If Your Lordships have no further questions, then I would like to ask my co-counsel to proceed with the further. Much obliged, Your Lordship. Your Lordship, just a minute of time to exchange of.
You go to which place?
Bangalore.
There. You?
Tamil Nadu.
The instrument should type in law, then we detect it.
Yes, sir. Yes, sir.
Questioning time is also adjusted, sir. Questioning time also excluded.
In the meanwhile, you are, all the people are note down. 1890, please note down the citation. 1890 SEC online. 1890 SEC online. SC. Case 200. This is a case of US Supreme Court with regard to the artificial intelligence. Please read it. 1890 SEC online SC 200.
That is why I am afraid of him. He knows the law. I am a spectacle. I am afraid that I do not have legal positions. Which I know.
Your Lordship, if you are satisfied with my counselor's argument, I would like to proceed with issue number 2 and issue number 3.
Please.
In issue number 2, whether the Honorable Court could issue directions in the absence of legislative action would be my first submission. Second would be is there a need for regulation for artificial intelligence? And third issue is regulating generative artificial intelligence to protect fundamental rights, public order, and national security.
What is the difference between you two? He has already argued all those matters. What is
Yes, Your Lordship, I would add on to.
He said you would argue some point and you would argue some other point.
Sir, please about these two. Yeah, now he will.
Your Lordship has asked those questions which were the part of my issues, Your Lordship.
Yes.
Hence, Your Lordship, if you have well the facts of the case, Siddhartha.
Your Moot number 2. For appellants.
Yes, Your Lordship. Your Lordship, the artificial intelligence, this technology has exposed various harms to.
Are you supporting artificial intelligence or not supporting?
Sir, I am supporting artificial intelligence, but with restrictions, Your Lordship. If Your Lordship may please, I would like to answer a question with respect to the question you have put forth some time ago with respect to should a judge be using artificial intelligence. I would like to mention it as for assisting, yes, and not to be a judge, Your Lordship. Your Lordship, the court in case of Lakshmikant Pandey versus Union of India emphasized the role of judiciary in safeguarding constitutional governance. When legislature has failed its citizens with respect to not keeping its citizens safe by and exposing them to harm. Your Lordship, with the advent of generative artificial intelligence, the threats of creating deepfakes, unauthorized impersonation, causing financial losses, violation of fundamental rights, personality rights, increased energy consumption by deploying large AI modules, and environmental harm and various other inequality related problems that might arise out of non-usage of AI by the general public. These are few of the harms that the citizens of this nations face. But the government, the legislature has failed to protect its citizens from exposure to certain harms, Your Lordship. And when such things has happened, courts has oftentimes
played a very vital, important role by intervening into the legislative aspect of it and provided guidelines. One of the major landmark judgment of Vishaka versus State of Rajasthan is an example for such judgment, Your Lordship. And when the legislature has failed to come up with a regulatory mechanism when in the due time, without wasting any time, the legislature has not done so. In that situations also, judiciary has stepped up and provided guidelines, Your Lordship, and in a way protected citizens. In the landmark judgment of Union Carbide Corporation versus Union of India, Justice Pathak too did the same in order to protect the victims of the Bhopal gas tragedy.
Did he protect the interests of the
At least
deceased?
At least he
He
made.
pretended. I think he pretended. That's all. Nothing more than that. Nothing. Did they receive any compensation? Even now?
Your Lordship,
No, you are saying
initially they did award certain amount, Your Lordship. That amount was meager, but at least he was the only judge who gave certain.
Did the victims receive that amount?
One thing.
Whether the culprit was punished in Bhopal tragedy?
No, Your Lordship.
Then how you have protection?
At least Your Lordship, the judiciary made sure even people get at least something better than nothing. Your
Have you
Lordship.
ever had the law of extradition?
Yes, Your Lordship.
What is?
It's a in international case law, if a person.
We could not bring him India.
Your Lordship, the judiciary tried its best, Your Lordship. If the legislature has not intended, then it's a fault of a legislature.
Law of extradition, if you commit a criminal misappropriation in India and you go to abroad, we cannot bring him. It is difficult to bring him to prosecute. He killed a lot, hundreds of people killed in Bhopal tragedy. Till now he is not punished.
Yes, Your
Only
Lordship.
compensation, certain amount, a meager amount, he may not.
Yes, Your Lordship.
Therefore, the Lordship.
No, sir, it's just because of judiciary the victims get.
He said he was taking it for granted that.
No protection, still we are struggling.
What is his name?
Justice
What are two?
Anderson.
Chief Justice.
Justice Pathak was.
Pathak was very generous and doing. He was not doing.
Not generous, sir, but at least.
He was not doing anything. Well, he was more interested in International Court of Justice, not in India. Yeah.
In India, Your Lordship.
Don't interrupt with our opinions. We are not.
We have citizens.
Don't
are
influence.
educated. As I'm a former judge, he is a sitting judge, we have our own opinion.
We are expressing our opinion. Repeat the opinion in the language of section 51 of the
Yes, please.
Your Lordship, even when the case is pertaining to public welfare which is at risk, the PI legislation and the landmark judgment of Badwa Mukti Morcha versus Union of India, the contribution of Justice Bhagwati and Justice Krishna here with respect to judiciary interfering to protecting the interest of citizens in the absence of law. When there is a legislative lacuna present, the judiciary has time and again come up with guidelines and legislation to protect the interest of citizens and importantly their fundamental rights. Your Lordship, the person who created generative artificial intelligence, the father of artificial intelligence is termed is called as who is called as Geoffrey Hinton, a Canadian citizen. He worked for Google for a longer part of time and he quit Google, citing there is some unethical way top big corporations are handling the issue, Your Lordship. And in paragraph 30, page number 20 of my submissions, we have spoken about the Reuters article written by Mariel Lemons, who speak on the generative tools and how they are perpetuating not only harmful gender stereotypes, which I will be establishing with taking some examples globally. Here, the top companies, Your Lordship, that are involved in the big giants technological companies, be it Meta, be it Twitter, formerly Twitter X, and Apple, the co-founders have themselves stated that the GPT version 4, after that it must be paused for a while until there is a proper regulations set in place. Your Lordship, GPT stands for Generative Pre-trained Transformer. Transformer is just a machine. This machine is fed with large amount of data which utilizes this data and come up with the output.
in GPT at least there is a human intervention, Your Lordship. In generative GPA, a set of pattern is being provided to a court, my apologies, Your Lordship, is presented to a transformer or a machine, large language module machine, that will predict what, it will take a probability of that and come up with a combination. In this, the way the machine come to the conclusion, whatever it reads, that is beyond human comprehension, Your Lordship. That beyond human comprehension of certain thing that comes out to the output, that is called a black box phenomenon, Your Lordship. That even the scientists or the creators themselves do not know and cannot themselves say that this module, this machine is reading this data in this way and coming up with this output. When they themselves do not, the creators themselves do not know it, then if it can be utilized by general public or by the countries at large, the threat becomes magnanimous, Your Lordship. And the company owner, Sam Altman, who is the owner of the company OpenAI, which has a product GPT, GPT-1, GPT-2, GPT-3 and GPT-4, which we are using presently, Your Lordship. This comes up with a text output for whatever the text input that we give. And there is if there is a text input we give and there is a image output, that technology is called DALL-E, and that is version 2, Your Lordship now. Now they have DAL 3 and DAL 4 that is in place, wherein it will create a video and CGI out of itself, Your Lordship. Like if people just tell it that I am expecting a kind of a picture or an animation that I want it to be like this, without any human coding or anything, it will process amongst itself based on whatever the data that is present on internet globally, and it will give an output, Your Lordship. Your Lordship, the author further goes on to say that this AI has been used by offenders, like people who wants to commit sexual offences or who are misusing the internet. They are using this to create hypersexualized content, which directly targets women and children, particularly, Your Lordship. And in Turkey, Your Lordship, they conducted a widespread research with respect to how AI increases the child abuse in their country. And they also, the research methodology involved the perception of violence, degree of violence, what is like physical pain, what are the things that can mentally affect the children. In that, threats involved unauthorized sharing of personal information and photos, and leaking of private information and photos online, a kind of a threat. These constituted about 88%, Your Lordship. That is more than what if a person is getting slapped, if a child is getting slapped, the amount of pain or a degree of pain that he feels is lower than compared to if someone is misusing their, if they are being threatened online, or if their photos are being leaked online, Your Lordship. And most of the images circulating on social media are synthetic, Your Lordship. They may not be true also. They are, it's kind of an impersonation. This has led to the children deteriorating their confidence within themselves, and also leading to what is termed as Facebook depression, Your Lordship. This is an
one question.
Yes, Your Lordship.
Judge has to use sense of law
Yes, Your
for
Lordship.
framing of a charge. In case of the facts of the case, isn't it disclose the particulars and content of the charge? Contents and particulars of the offence. Then judge has to use his sense of law according to section 220 of the Code of Criminal Procedure. In BNS, there is a section 243 of Bharatiya Nagarika Procedure 243. We have to use our sense of law to frame a charge. Can you use how the artificial intelligence will assist the judge in such a time to use the sense of law, because there is no sense, it is a misworking device. How I can frame a charge by using the sense of law by taking the artificial intelligence
Yes, Your
to
Lordship.
attract 220 of CRS.
Your Lordship, the judge can surely take a use
I
of.
have to frame a charge by using my sense.
Yes, sir.
If
There is
how
yes, sir.
the charge you. If I permit you to invoke usage of the artificial intelligence, how can you answer it?
Yes, Your Lordship. As I earlier mentioned, AI can assist judge, but not become judge. The judge himself is well versed with the realistic and ground situations. If he can write a statement in a haphazard order, let's assume the sentences are framed in a, which should be 1, 2, 3, 4, 5. If it is framed 3, 2, 1, 4, 5. AI, if he gives the data to AI, the AI will provide it in a systematic way. Yeah, the more it's more of a like it's more like it does more of a paralegal job.
Like this, the information generated by AI is misinformation, manipulated information. How can you justify?
Your Lordship, I would like to again quote.
The information generated in AI.
Yes, Your Lordship.
Is false information. That's my comment. How can you argue?
Your Lordship, primarily I would like to quote the person who founded AI himself. He has told, Geoffrey Hinton has told, there is so much fake news that people won't have any grasp on what is truth. Which in a way states he himself has identified that people, there will arise a situation where people themselves will not know what is true and what is false. That there is so much of misinformation today that what is real information we are not aware of it, Your Lordship, until it comes from an authoritative source. And this, we cannot allow AI or any content that is generated out of artificial intelligence to be considered as primary source or a secondary source or a tertiary source at this point, Your Lordship.
Arbitrator has authority to enact the law.
Yes, Your
Why
Lordship.
did you approach this court?
Your Lordship, primarily my concern is with respect, there is a
We
second.
have no authority to make a law. We have to interpret the law. The arbitrator has authority to enact the law with regard to artificial intelligence. Why did you come to this court?
Your Lordship, I would like to argue on 2 points, Your Lordship. Primarily, the cases that I have mentioned, these were special cases wherein even then the legislature had the power to enact the law, but they were reluctant with respect to providing any justice to the citizens or with respect to creating a legislation that would safeguard the interest of the citizens, Your Lordship. If I may give you the why they are reluctant, example, Your Lordship, there is a secondary resource, Annexure 21 report on Committee on Cyber Security, Safety, Legal and Ethical Issues, Your Lordship. Therein, 62% of security experts believe that artificial intelligence will be weaponized and used by cyber attacks within 12 months. It was mentioned in August of 2017, Your Lordship. Now we are almost a decade later, Your Lordship. Almost a decade later, Your Lordship, the same person whom I have quoted, he is the recipient of Nobel Prize for Physics in 2024, Your Lordship. He said, I would wish that I had thought about the safety earlier before creation of this. And he says he has a potential, and he fears that the potential of AI using up for arms race, AI will be used for arms race, Your Lordship. And what he has feared has already become true, Your Lordship. There is a United Nations backed a think tank, Your Lordship, Tech Against Terrorism. They have provided examples of various terror outfits, militant groups around the world which are using generative AI content to propagate their ideology, and in a way which I would like to present to give you some examples, Your Lordship. A pro-Islamic State tech group in Syria, Levant, have advised their network to secure AI generated content and also AI generators, the equipments that are required to create generative AI. And there is, as my co-counsel has spoken regarding tech against, there is one messaging channel, Your Lordship, that is already present on Google Play Store, Your Lordship, wherein people are creating meme wars. If the people, we are living in a very kind of a polarized world where people are speaking out in a very derogatory terms, even if they have political affiliations. In Germany, where in various countries, the founding fathers of their countries are being ridiculed. Excuse me. They are using AI generated images to create memes, Your Lordship. And also, we have many examples that we have. We have many.
There is a note in your material, law prevailing in the Republic of India are in pari material.
Yes, Your Lordship.
With that of the Republic of India. What is pari material?
In consonance with
Give me one example.
for example, Your Lordship, Constitution of India.
Give me an example comparing the Code of Criminal Procedure and Domestic Violence Act. How you can apply the doctrine of pari material for these two enactments?
Your Lordship,
For example.
No, can you repeat the question?
Correct. You are correct. Tell it. Tell in your own way.
No, Your Lordship, I lost that.
What?
Paramateria, give an example of paramateria, please.
Your Lordship,
Have you read your problem?
yes, Your Lordship. In parameter is nothing but in the sense, if a kind, whatever the laws of India exist, it also exist in Republic Union of Indica.
No, that is paramateria, that's not what his lordship is asking. Give an example.
That is there. That is there. I also read it. You have, whether you have understand the word paramateria or not? What
Similar.
What does it mean?
Yes.
Right.
Yes, sir. If I
See, for example, in section 125 of CRPC,
maintenance. Yes, sir.
if the same provision is there in any other enactment, it is valid.
Yes, sir. Yes, sir.
Okay? Existing of the same provision in two enactments is called
Same subject matter with different provisions in different statutes.
yes.
And Your Lordship, coming back to the examples, Al-Qaeda output has published several posters of high images likely to be created using a generative AI platform, Your Lordship. When these things are used by the anti-social elements and terrorists, Your Lordship, they potentially wreak havoc within the lives and well-being of the people as provided in the Moot code problem itself, Your Lordship. These are one of the feared reasons why NGO has taken upon itself to in the interest of
papers and argue for 2 minutes.
Sir, Your Lordship, if I were to take another example with respect to how generative AI content has been used for impersonating and defaming even our constitutional makers, Your Lordship. A few days ago, there was parliamentary uproar with respect to the concept.
Let's not go into politics.
Yeah, yes, Your Lordship. No, but my contention was that these content are generative AI has been used to create these contents. Hence, Your Lordship, if at all, if there is no regulations that are in place to govern this output, the outcome of a generative AI, then in the absence of any specific law with respect to this, and if I may to give examples, Your Lordship, there is, the respondent may say there is IT Act, there is copyright law and other special legislations.
Why can you use artificial intelligence in court of law?
Yes, Your Lordship.
How? It generates fake citations. What would you do?
Not for research, Your Lordship.
Huh?
Not for
The
research.
lawyer prepares an argument, they
Yes, sir.
submit to the court, and uses artificial intelligence. The artificial intelligence, like ChatGPT, has generated fake citations. You didn't check them. Then can you directly submit the fake citations to the court?
No, no, Your
How
Lordship.
can it be? You have not checked. You have received some information. You have not checked whether it is fake or not.
No.
Still you don't submit it to court.
How can you just say that the intelligence?
Your Lordship, that is the mistake of an advocate. He is going against the ethics code or ethics of. He cannot misguide the court. Your Lordship.
We are confined to using the.
Every advocate misguided us. It was our duty to be guided properly. We are advocate. That's one of the part of advocacy to misguide a judge or to confuse a judge. Therefore, of course, theoretically you should not misguide. No, what his lordship is asking you is specific question. You relied upon artificial intelligence. A series of nations have appeared. True. An advocate should check up whether it is really correct or not. You have not checked up. How do you know that is a false citation first? And secondly, do you cite it in the court or not? If you cite it, why? If you do not cite it, why?
Your Lordship, primarily, if an advocate, as an appellant, we are asking for guidelines only for this reason that the chances of generating AI giving fake citations is more. So we acknowledge that there is a problem with respect to AI, henceforth, I personally would not take up AI generated citations. Secondly, if
another simple fact, the information generated by ChatGPT is incorrect. That's my statement. The information generated by artificial intelligence is incorrect. Amma, you deduct my time. Whenever we interfere, you deduct and give the exact, okay? ChatGPT generates some information. The information generated by ChatGPT or any other mode of artificial intelligence is incorrect. That's my statement. How can you justify? I will give a direction to the legislature to enact a law. If I have a power, tell me.
Your Lordship, 2 days ago, if I may use example of my personal experience with respect to asking GPT a question, Your Lordship. I personally asked GPT certain questions, Your Lordship, and it came up with different answers, Your Lordship. I went on to ask.
I say that information is incorrect.
Yes, Your Lordship.
How can you justify?
The chances of it giving incorrect answers are really more, Your Lordship. That is what I am trying to demonstrate here.
So what would you do?
Henceforth, we require guidelines wherein the company. No, Your Lordship, the company themselves.
I am not a tech savvy. I don't know. I am a judge here. I don't know what is the technology. What is your answer? I don't know. I give a guideline. I don't know what is the technology. The court does not know does not know about the software.
Your Lordship, the court.
You enlighten me, then I will give you a guideline.
Your Lordship, it will come up with the fake answers. Henceforth, it should not be accepted. Is my.
What we have to do for the correct that incorrect information.
Your Lordship, the courts presently use neutral citation as one of the way of accepting which are the citations have to be accepted. They use even
recently we have come across the case a lawyer cited fake citations by using artificial intelligence and submitted to the court, and the court has taken action against that lawyer.
Yes, Your Lordship.
Have you come across?
Yes, sir. Yes, Your Lordship.
How would you justify your argument to pass guidelines?
Your Lordship, there is if the court has been used, if the court has primarily mentioned that these are the citations with respect to cases, these are the portals from which we are accepting citations, then the question of me citing some other source does not exist in the first place, Your Lordship. And also, Your Lordship, in Supreme Court, I apologize for not remembering the case of the.
Therefore, I issued 1890 SCC on the SC case 200. The judgment of US Supreme Court with regard to usage of artificial intelligence. Have you gone through it?
Your Lordship, I went through one case law which was with respect to COMPASS, a kind of a software that US one of the district court in US has used pertaining to how they use artificial intelligence. But what happened in that, Your Lordship, is that the CCTV the cameras used and they segregated people and they came up with a bias. The people with color were given with certain statements and the people with who were white were given certain statements, Your Lordship. That was because of the human bias that was used in feeding the system in the first place. If what happens by using certain such artificial intelligence technology in judiciary is like it undoes what the constitutional makers have fought for long, Your Lordship. For it will only amplify the faultiness that are present within the society, and what our constitution and the frameworks of our constitution aspire will be destroyed, Your Lordship. Hence, the threat of AI causing problem within no time is more than compared to.
Submit your case in 5 lines. If you think that you are a ChatGPT, submit your case without using any paper. Submit your case in 5 lines. Brief.
Your Lordship, generative AI has a probability of giving output that can put individual privacy, society and nations at large at risk. And these technology can be, these are not time variable. In a matter of minutes or seconds, things can become extremely bad and the damage done is irrevocable. Hence, the appellant plead before honorable bench that interim guidelines are of utmost importance.
What interim guidelines you have?
Primarily, Your Lordship, there is the LegaL law that I personally identified after reading IT Act as well as Bharatiya Nyaya Sanhita is like the concept in IT Act there is a concept for intermediaries and there is a if at all the content is generated using an AI that causes right in our society and people are killed and enmities amongst the amongst religion on religious lines or caste lines has been taken place already, Your Lordship. Who will be held responsible, Your Lordship? Will it be the company which has that generative AI, or will it be the internet service providers, or will it be the platform? If at all, if there is any app, who will be held responsible? That question is absent, Your Lordship. There is no answer with respect to the same, at least in Indian law as of in the Republic of India, Indica as of now, Your Lordship.
What he is, Lordship, and I have been asking is, what guidelines do you expect? What guidelines? Simply saying guidelines. Guidelines, what are the guidelines? Suggest a couple of guidelines.
Your Lordship, primarily to establish an oversight committee within the company who has who intends to enter into the market. What will that oversight committee does is, what will be the inputs, the way, the ethical inputs that they are providing. There has to be this mechanism where they have to provide that machine.
I understand, yes.
And there must be mandatory registration of those companies in Indian laws. In India, Your Lordship.
Simply register, then what?
Your Lordship, if they are registering, then they also come under different statute until the legislation has a clear legislative mechanism set in place with respect to dealing AI, Your Lordship. Like for example, if a Gen AI machine is in Pakistan, for example, Your Lordship, they create certain content that leads to problem in our country that is not regulated in our country. But if there is a mandatory registration, then it also comes with certain liabilities, Your Lordship. That is
what I am asking. That's exactly what I am asking. Simply registration does not what exactly what you are asking? Registration is it sufficient?
No,
nothing else.
No.
You simply register the company here. That's what exactly I am asking. Then
registration along with certain liabilities if any content is generated out of that company, Your Lordship.
A regulation must be there.
Regulation.
That's what you are saying.
Yes, and then there has to be cyber security protocols, Your Lordship. And then there has to be the oversight committee, people who are in the oversight committee, they must be trained in mitigating bias of the machines, Your Lordship.
Write a word. It's LegalU. CINATE. Pronounce it correctly.
Hallucinate.
What does it mean?
So to pursue something which is not there.
Use ChatGPT and tell me. Okay, you do it exercise. Okay. Yeah, you remember that word and you search for the Lordship for Dr. KG Center, Judge High Court of Andhra Pradesh, what it means. And you search any name and you search my name, Vice University Judge, Dr. Vice University Judge, and I after type it, gives you a lot of information. Does it is correct? If you search my name and generate the articles written by Vice University Judge, then it gives a lot of data. Is it all correct?
No, Your Lordship.
No, how you can say?
Sir, Your Lordship, again.
So far as your lordship understand, whatever is there in the internet is correct. I personally don't.
Then how can you justify your
It has not given any.
whether it is correct or not?
Okay,
It shows like I am a jurist, it shows like, for example, so your lordship is a jurist, shows. Otherwise, the innocent people will be just saying that my lordship is a jurist, or vice versa. He is a jurist. Some points are correct. More points are incorrect. It appears to be incorrect. In such a way, what we have to do more?
Henceforth, we put
One word answer.
so
What we
oversight
have to do more?
mitigating bias and having a oversight mechanism with respect to the way the generative AI provides content.
We have to do a lot of research. Still, investigations are going on
Yes.
to develop that research. In such a way, you are
Your Lordship, if you may permit me to proceed in the prayer.
Your time is there.
Yes, yes.
No, Your Lordship, we would like to proceed with the prayer.
Over.
Yes, sir.
You both have presented
Do you want to?
wonderful presentation.
Thank you, Your Lordship. We would like to proceed with the prayer, Your Lordship, if you do not have any query.
Yes, please. You said that you have finished.
No, sir. Sir, asked,
That's not in our
Please proceed.
Therefore, in the light of facts stated, arguments advanced and authorities cited, it is most humbly prayed before this honorable bench that it may graciously be pleased to allow this appeal, issue directions to policymakers to formulate and enforce a robust regulatory mechanism to regulate generative artificial intelligence and AI technologies, and in the interim frame guidelines until the legislature intervenes, and pass any order which the bench seems fit in the interest of justice, equity and good conscience. Thank you, Lord.
Yes, let us start.
5 minutes.
Ouch. Phone. Chair, please. I'll do it. అన్న ఏసీసీ వచ్చి కట్టి వాటర్ వచ్చేస్తుంది నేను బ్యాగులు తెలుసు పక్కన పెట్టాను
Before starting, you mention your name and your state.
నా లైక్ బాక్స్ మీరు ఇక్కడ పెట్టేసి నేను చూసుకుంటాను
I never used the mic in the court law.
Want to interact with the
Yes, please.
The council seeks permission to address the bench.
What's your name?
My name is Tarun Pranav, Your Lordship. Tarun Pranav. Tarun Pranav. Yes. May it please the Honorable Moot Court of India. I am from Tamil Nadu, Your Lordship. May it please the Honorable Moot Court of India. This is the Attorney General, assisted by Solicitor General, along with Additional Solicitor General, representing the respondents in the case of Tech with Human Face versus Union of Indica and others. If Your Lordship permit facts cognizant to the respondents, or shall I move on to my arguments, Your Lordship?
Yes, you like.
I will move on to my arguments, Your Lordship.
Please, the time allotted to you is only 20 minutes.
Yes.
You can use it as you like.
I will use it for my arguments.
Whatever is ready.
Much obliged, Your Lordship. The council seeks permission to address the bench collectively as Your Lordship. Much obliged, Your Lordship. The council seeks permission to present compendium on behalf of the respondents.
Yes.
Your Lordship, the maintainability. Your Lordship, shall I start?
Yes, please.
Much obliged, Your Lordship. Your Lordship, the maintainability on the appeal on the PIL is not maintainable, Your Lordship, in the face of this court, Your Lordship, as there is no any advent error in the face of the court of before President, Your Lordships, by the judgment of Supreme Court of Indica, Your Lordship. Your Lordship, the special discretionary power of the Moot Court of Indica in the matter should not be exercised without carefulness, Your Lordship, in this present matter, Your Lordship. Your Lordship, I would like to substantiate my arguments into 3 submissions, Your Lordship. One is there is no locus standi for the appellants in the present matter. 2, there is no substantial question of law. And 3, there is no violations of Part 3 of the Constitution of Indica, Your Lordship. Your Lordship, may I move on to my submissions, Your Lordship? Much obliged, Your Lordship. With regards to the locus of the appellants, Your Lordship, PIL must be rooted in genuine public interest, public concern, Your Lordship. Here, the only one NGO who is putting forth and fighting for the regulations over generative artificial intelligence is Tech with Human Face, Your Lordship. Therefore, we can say that they are framing a private interest litigation and adversary litigation, Your Lordship, just to gain a advertisement for, and as clearly stated by Lordship P.N. Bhagwati, they have some oblique consideration with regards to this maintainability of PIL, Your Lordship, by this SLP, Your Lordship. Your Lordship, AA has easen the life of people, Your Lordship. If you may refer to the Moot Court proposition, Your Lordship, in this first pair of the Moot Court proposition, it has been clearly stated that AA has been using, AA is being an indulging part of people of Indica, which eases their life, Your Lordship. Your Lordship, I would like to drive your attention to the flag G of the compendium presented. Flag G, Your Lordship. Much
You need not on permission of the repeatedly. You can submit whatever you want.
No, Your Lordship, if you may refer to the flag G of the
All right, we'll see.
Okay,
Proceed.
Much obliged, Your Lordship.
Proceed, we will see.
In the case of State of Uttarakhand versus Balwant Singh Chowfal 2010, it has been clear in the ratio, it has been clearly stated that PIL must demonstrate a clear nexus of public harm, Your Lordship. And therefore, as the earlier judgment clearly stated that there is no public harm and this is not a matter of public importance, Your Lordship. Therefore, this PIL is not maintainable, Your Lordship. And PIL cannot be based on mere half-baked truth, Your Lordship. It should not be on the mere speculations or hypothesis, Your Lordship. For this, if you may refer to the Your Lordship, in the case of K.S. late retired Justice K.S. Puttasamy versus Union of India 2017 10 SEC 1, Your Lordship, it has been clearly stated in the highlighted points, Your Lordship. It is one of the ratio of the judges, Your Lordship. Reasonable expectation involves into 2 aspects, Your Lordship. Drawing your attention to 3rd line, Your Lordship. This concern should be real and not imaginary or speculative, Your Lordship. As stated by the learned brother councils of the appellants, the claims of the claims on the regulations are mere speculative, Your Lordship. Therefore, there is no any empirical.
It's not an imaginary. They are giving data. It is visible.
No, Your Lordship. The data are.
Artificial intelligence use data. You can see it. It's not an imaginary.
Indeed, Your Lordship. But the claims are very speculative, Your Lordship. However, I will say it in my following arguments, Your Lordship. Much obliged, Your Lordship. Your Lordship, if the executive is not carrying out their solemn obligation, the court can intervene and invoke their jurisdiction to do their solemn obligation, Your Lordship. Whereas in this case, the government of Indica is doing their solemn obligation and they are particularly enacting laws with regard to this, Your Lordship. For this, if I may. There is a proposal, Your Lordship, My learned brother, the learned brother counsel of the appellant has clearly stated that there is no authority, your lordship. There is no authority or any part for regulating this, your lordship. However, in this present matter, the government of Indica is proposing a Digital India Act, your lordship, and this technologies has emerged in the 2022 effectively in India, your lordship. Therefore, we need to collect, and it is based. These technologies is based of a lot of technicalities, your lordship. For this, we have to require records and how to speculate it and how to make laws, your lordship. Further, we are framing some guidelines and we are framing some statutory bodies by the way of Digital India Act 2023, which going to be enacted very soon, your lordship. Your lordship.
What is your objection for this case?
Your lordship, we have objection, your lordship. I would like to.
You are framing the act.
Yes, your lordship.
They are exactly asking you to frame law,
Yes,
frame
sir.
regulations.
They are also seeking the same.
They are seeking.
Yes, your
You
lordship.
are framing it. Then what is the objection?
No, your lordship, they are stating that the learned brother counsels in their arguments and pleadings stated that there is no authority and there is no any part of government involving in this matter, your lordship. But however, if you may refer to the document presented over, your lordship.
Only inventions are going on.
Indeed, your lordship.
With regard to artificial intelligence, they are seeking the codification
Indeed, your lordship.
and enactment. You are also doing the same. How it is justified to your case? You are also submitting the act is being codified. They are also seeking for codification of artificial intelligence law. You are also doing the same. How can you support your argument to this
Simply stating we have no objection. Pass the order as they are asking.
Indeed, your lordship. However, they are seeking.
The point is whether public interest is involved in this case or not.
I will substantiate in my following arguments, your lordship, and they have stated that judicial intervention is needed in this present matter to give interim guidelines, your lordship. However, I have submitted.
No. Please. If the government is not ready to do it, then the interim some directions, and in the meanwhile, if necessary, some directions may be given. They are not asking for directions from the court. They are asking for the government to pass legislation. In the event government is not willing, then you please step in. That's what they are asking, basically.
Your lordship, in the prayer of the pleadings stated that they have in the third prayer they have mentioned that the alternative frame interim guidelines through the court they have mentioned, your lordship. In alternative.
When you have framed guidelines,
Yes, your lordship.
where is the point in alternative?
No, your lordship, I would like to substantiate in further, your lordship. And also, if you may refer to the document presented, it is provided by the Ministry of Electronics and Information Technology with regarding to the generative artificial intelligence, your lordship. If you may refer to the point A, 2 clause A, your lordship, in this paper, your lordship.
Okay, you read it when you hear.
Much obliged, your lordship.
Please, all of you switch off the phones or put them in silent mode, please. Yes.
Indeed, your lordship. In that, this paper, your lordship.
You did it.
Indeed, your lordship.
Here.
2 clause A is clearly stating that every intermediary and platform. Here, the word platform is clearly suggests that all the models and all the technicalities, devices of generative artificial intelligence in way it is going to invoke, your lordship, and also following should ensure that use of artificial intelligence models /LLM /generative AI. It has been clearly stated in the Ministry of Electronics and Information Technology. Generative AI softwares or algorithms through its computer resource does not permit its user to host, display, upload, modify, publish, transmit, store, update or share any unlawful content as outlined in the Rule 31B of the IT Act 2000, your lordship. Therefore, it is read with IT Act 2000 and also read with the upcoming DPDP Act of 2023, your lordship. Also, the 2 clause C is clearly states that, apologies, your lordship, 2 clause B clearly states that does not, in the last line, does not permit any bias. The word bias stated by the learned brother counsel appellant is denying this fact, Your Lordship, of their pleadings, Your Lordship, does not permit any bias or discrimination or threaten the integrity of any process, Your Lordship, any process of the government of Indica and the people of Indica, Your Lordship. And also the two clause 3 is stating the same, Your Lordship. If Your Lordship are of no any further assistance, I would like to move on to my second limb of my submission, Your Lordship. Much obliged, Your Lordship. Much obliged. There is no violation with part regarding to the upcoming emergence of generative artificial intelligence, Your Lordship. Your Lordship, as the court's jurisdiction in the matter of Article 136, there should be a clear violation and there should be a substantial question of law, Your Lordship, of a great debate in the absence of any any statutory bodies or any guidelines, Your Lordship. However, in the present case, with regards to substantial question of law, there is being a statutory bodies with regards to the generative artificial intelligence, Your Lordship. And moreover, there is no violation of Part 3 of the Constitution of Indica, Your Lordship.
Tell me one question. The electronic means has been defined in BNSS.
Yes,
have
Your
you gone
Lordship.
through the recent criminal law amendments?
Indeed, Your Lordship.
The word electronic means or electronic communication has been defined in BNSS.
Indeed, Your Lordship. It has been. It is there, Your
It
Lordship.
should be there. See, listen how it is to be reached. If there is a definition of electronic communication in Bharatiya Nagarika Suraksha Samhita, whether that definition has been given in Indian Evidence Act or Sakshi Adniyam,
No, Your
Bharatiya Sakshi Adniyam?
No, Your Lordship, but it
No,
has been.
no, that's. Is there any definition with regard to the electronic communication in Adhiniyam when compared to the Information Technology Act 2000? We have to compare the Information Technology Act, Saksha Adhiniyam, as well as Nagrik Suraksha Samhita. The definition is given in recent law, but it was absent in Adhiniyam. How can you interpret that definition, whether it is to be added or not? But the legislations are showing interest to enact certain laws for technology. Artificial intelligence is also one of the technologies. Then how can you resist their case?
Indeed, Your Lordship, but in that.
We are in development. India is a developing country. We are making inventions for the public welfare purpose. They are also asking the same. The public interest litigation is involved in this case. Permit and they appoint a committee for more investigations with regard to the intelligence. How can you dismiss their case?
Indeed, Your Lordship. However, one part of your question will be answered thoroughly in a substantial way by my counsel too, Your Lordship. However, in the present case, IT Act 2000, in the absence of BSA Bharatiya Sakshi Adhinayam, in the absence of the exact definition, it is being clearly stated in IT Act 2000, Your Lordship, with regarding to the punishments and with regarding to what are the electronic means, Your Lordship. However, it is all in the absence of in BSA. IT Act is fulfilling the lacuna, Your Lordship. This is my stance by.
If court passes guidelines or give directions to the Union of India, what would be wrong to the people? If we permit for more investigations on artificial intelligence for the purpose of public welfare by allowing this bill, what would be the wrong there?
Indeed, Your Lordship. However, the committees and bureaucratic.
What are the infirmities would be caused to the people? Explain.
Indeed, Your Lordship. But however, there are committees by legislative.
We appoint a committee to do more research on artificial intelligence. Is it wrong to the public?
It is not wrong, Your Lordship. But however, it is not wrong. But however, Your Lordship, before this petition has been filed before this court itself, the legislation has been enacting several, has been appointed several bureaucratical controls and committees with regard to the same, Your Lordship. GPA.
What I wonder, when what they are asking, that you are providing, why do you resist it? I
Indeed, Your
I
Lordship.
wanted something. That's exactly what you are doing. Then why do you resist this petition? You should simply say, we have no objection, pass the order.
Indeed, Your
That's what I
Lordship.
felt. When you said that you are passing legislation.
Indeed, Your Lordship, but these types of PILs is spreading in the courts, Your Lordship. However, the states are...
So you are saying, you are coming to the point that it's blackmail, therefore it should be resisted. That is only your point.
Indeed, Your Lordship.
Is it your only point?
Can you repeat the question if you
Is it,
Lordship?
but this PIL is nothing but a blackmail, and therefore we are resisting it. Is it your point?
No, the word I
All right,
don't...
then, forget blackmail. They are doing something incorrect information.
Yes, indeed, Your Lordship. They are trying to frame some adversary effect in the face of the court, and they are trying to gain advertisement and oblique consideration as stated by...
Develop the argument in that area. Develop your argument in that area. It gives incorrect inaccuracy, and it is a machine. It has no sense. Like argue.
Indeed, Your Lordship, it will waste the time of the court, and already legislation is working on it, Your Lordship. Already legislation has enacted several bodies and regulatory bodies, bureaucratic bodies, and IT rules and enactments, Your Lordship. However, if this court is passing any orders, then there will be a confusion with regarding to this same, Your Lordship. Whether we have to follow the guidance made by this honorable court, or whether we have to follow the legislation, Your Lordship. In order...
You have such a doubt.
It will happen.
Such a doubt for many people. When court passes an order against a legislation, is there any doubt that the legislation is to be followed or the direction of the court is to be followed? I just don't understand.
No,
if there is such a confusion for anybody, I'm very sorry about it.
Indeed, Your Lordship, it will cause discrepancy. That is the standard.
That's a different issue.
Yes,
If there is a discrepancy. See, legislation says one thing. After the legislation said something, the court said something else. Therefore, what the court said is is binding on all the person, particularly after 142 and 141 articles. It is binding on everyone in the country.
Indeed, Your Lordship, I would like to substantiate in my arguments, Your Lordship, with regarding to this, Your Lordship. If you may refer to the flag B of the compendium presented over you, Your Lordship. Flag B of the compendium on behalf of the respondents.
Yes, please.
Flag B.
B, Your Lordship.
Yes, please.
Your Lordship. Your Lordship, in the case of Ashok Kumar Pandey versus State of West Bengal, which is flagged as B, this case clearly states that if the cause of the action has no violation, or that the petitioner or appellant has no locus, they can't file a case as a PIL, Your Lordship. Here there are no violations of fundamental rights in the Part 3 of the Constitution of India, and bureaucratical oversight is clearly seeing and overseeing these regulations, Your Lordship.
If there is locus, where is the question of PIL? PIL arises only when there is no locus.
Yes, Your Lordship.
Then how can you say, no, if there is a locus, if there is
They
no
don't
locus,
have the locus, that is my
then
stand.
that cannot be. If there is locus, why should they file a PIL? They will straight away file a case. Why should they file a PIL? PIL is, see, something like habeas corpus, for PIL, locus is not needed.
Indeed, Your Lordship, this is not a matter of habeas corpus. They are seeking the judicial to intervene into the matters of jurisdiction of legislation, Your
Locus
Lordship.
does not arise. That's what I am saying. Locus does not arise in a PIL.
Indeed, Your Lordship, it has
If
been
it is
relaxed.
causing any harm, that's a different issue. It's causing, it's not causing harm, etc., etc. They are all different issues. But locus, I personally feel.
However, I'm highlighting the point over no violation, Your Lordship.
Okay.
If the matter is does not cause any violation, the PIL should not be maintainable, Your Lordship.
Yes.
Also, Your Lordship, in this present case, they must show some empirical data with regards to the jurisdiction of Indica, Your Lordship. However, the empirical data or any facts or evidences which is being applied to the jurisdiction of Brazil will not bind over, Your Lordship. However, this is not a matter of extraterritorial jurisdiction, Your Lordship.
Let me one word, what is locus standi?
Your Lord,
One word.
the person who is aggrieved may file a case, Your
No,
Lordship.
what that exact locus standi means? How do you understand the word?
By the interpreting locus standi, I will suggest that
Say he has a locus standi. How do you understand it?
if he is a genuine petitioner or if he is genuine, Your Lordship.
Genuineness is-
If he is not a genuine or if he is
Yes, right.
much
Bona fide.
bona fide or much obliged, Your Lordship. Your Lordship, if you may refer to the flag H of the companion on represent respondents, Your Lordship. Flag H, Your Lordship.
Yes.
Flag H of the companion.
Okay, you go on.
Much obliged, Your Lordship. In the case of Ashish Narayan versus Dev Chandra, the highlighted points clearly states that PIL cannot be entertained on mere speculation without evidence or any empirical data, Your Lordship. Therefore, in the face of this court, I am humbly requesting to dismiss this PIL, Your Lordship. Also, with regards to the substantial question of law, however, my third part of my submission is there is no substantial question of law, Your Lordship. Your Lordship, the matter on regulation of AA doesn't qualify as an exceptionality case as mentioned in the Article 136, Your Lordship. Article 136 has been clearly stated that the court has the discretion to allow if a case is of exceptionality or if a case is of public matter, Your Lordship. However, in this case there is no exceptionality, Your Lordship. Why? Because the government of Indica and the bureaucrats are been working restlessly with regards to the formation of new statute, and they have also gave some interim guidelines by the way of Ministry of Electronics and Information Technology, which has been presented before Your Lordship. Therefore, this case is not of a exceptional. This case is not a exceptionality case, Your Lordship. Your Lordship, however, substantial question of law should be qualified when there is a violation of Part 3 of the fundamental rights or any fundamental rights has been violated, Your Lordship. Therefore, in this present matter, there is no violation with regards to the right to privacy which has been submitted through the way of K.S. Puttaswamy case. If the matter is on mere speculation, the matter will not be entertained as PIL or matter will not be entertained as a debate of substantial question of law, Your Lordship. And Your Lordship, if you may, Your Lordship, if you may refer to the page 15. Your Lordship, if you may refer to the page 15 on the memorandum of the respondent, Your Lordship.
Okay, memorandums are there separately. Yes.
Much obliged, Your Lordship. In the case of page 15, Your Lordship.
Did you submit to us?
Memorandum in response.
Yes, please.
Much obliged, Your Lordship.
You have done a lot of research work.
Your Lordship.
You have done a lot of research work.
Indeed, Your Lordship. In page 15, we have clearly quoted in the italic fonts. In the case of K.K. Verma versus Union of India, Indica, 1954, Supreme Court records 394, this Honorable Court made it clear that substantial question of law must show a direct violation of constitutional powers amended through the way of Part 3 of the Articles of Constitution of Indica, Your Lordship. Therefore, in this case, there is no violation, and this case is supporting our pleadings, Your Lordship. Also, in this case, the appellants are merely seeking legislative action by the way of intervention of judicial power, Your Lordship. Wherefore, it is beyond the judicial mandate, Your Lordship.
They also submitted a material. You also, huh?
Yes. Please proceed.
Your Lordship, at last, with regarding to the three submission of the issue number 1, if you may refer to the page 13, Your Lordship. Page 13.
Please go ahead.
Much obliged, Your Lordship.
Please, how much? For everything you are asking, please go ahead. Please
If
go
you
ahead.
may refer, it will
Yeah,
be
please
easier
go ahead.
to
Please go
understand, Your
ahead. Who will
Lordship.
speak the matter? Please go ahead.
Learn it typically as an advocate. Advocate should have more skills. What is the duty of the advocate is, the fundamental duty of an advocate is to convince the judge, but you should not embarrass the judge.
No, Your Lordship.
See,
My kind apologies, Your Lordship.
You're right, but listen, you're right, I'm finding fault you. You have to convince the judge. How the judge will feel free and hear your point. You repeatedly ask me, see this, see that, I will embrace. Okay, I have patience, I can look it. Some judges may look rigidly. They don't want to see any paper, they want to only listen. Then you interpret, see this page, you see that they will.
There will be error.
Thank you for guiding the council, Your Lordship.
I'm not saying all the judges like this, but you have to understand the mentality of the judge. You try to convince the judge. You have convinced me. Other lawyer sold me dumped me a lot of judgments. Who will win?
My kind of political lordship.
No,
However,
I'm not finding fault. There are several skills. We have to learn. You have to show. It's a wonderful skill you have. You are giving a judgment and asking the judge to refer it. Wonderful. It's really wonderful. At the same time, you should not ignore the mentality of the judge.
kind of prejudice.
Don't apologize. Don't apologize. You are a lawyer. You have a voice to represent.
Indeed, Your Lordship.
Whatever it may be my opinion, I will judge you. I give you an opinion. It may be incorrect. The other form will correct it. But you are a lawyer. A lawyer can change his word at any point of time. But judge cannot.
Indeed, Your Lordship. Thank you for your guidance, Your Lordship. In that case, the court should, it has been clearly held in the ratio, court should not entertain a appeal which is based on mere allegation and half-baked truth. Again and again, I am repeating on the speculation point. Why? Because their claims are basically on the part of speculation, Your Lordship. And the Ministry of in Electronics and Information Technology is there for everything with regards to the guidelines and with regards to the regulations over the generative artificial intelligence, Your Lordship. With regards to the third issue, I will submit two parts of the third, Your Lordship. If Your Lordship are of no any further assistance, the Council may move on to my third issue. Much obliged, Your Lordship. Your Lordship, the third issue is whether the absence of global regulation must have an impact on Indica's national regulation, Your Lordship.
Yes, proceed.
Much obliged, Your Lordship. The absence of domestic framework for generative artificial intelligence may influence or may guide, but not dictate the legislation to work on the particular law. As already stated, the legislation are already working restlessly, Your Lordship.
Please repeat. I did not catch.
Much obliged. Sorry, apologies, Your Lordship.
Please repeat. What you said? I did not catch you. Please again.
Much obliged.
Indeed, Your Lordship.
Say much obliged.
Please.
Indeed, Your Lordship. The absence of domestic framework with regards to the Indica must not dictate or must not dictate or influence the legislation to work on the enactment of new laws. As already stated, legislation and the bureaucrat bodies are working on the formation of new framework, and in the meantime, we are giving interim guidelines to the way of bureaucracy control by the way of Ministry of Electronics and Information Technology, Your Lordship. Also, Niti Aayog is a formation committee, and it is also framing some guidelines over the generative artificial intelligence and usage of your generative artificial intelligence, Your Lordship. Your Lordship, domestic laws could lead to fragmented and ineffective legal response with regards in a matter of transnational border, Your Lordship. As stated in the Moot Court proposition itself, this is a matter of global relations, and the MNC Zenitech is already there in multiple countries, Your Lordship. However, this is a matter of transnational borders. If we regulate this generative artificial intelligence as a unilateral policy, it will cause economic disruption, and it may leave the other investors from the country, Your Lordship. As if you may refer to the DIA Act, the Atmanirbhar of the Indian economy is trying to seek 1 trillion economy, Your Lordship. For that purpose, if we regulate this generative artificial intelligence at the emergence or at the growing stage, it might stifle the innovations, Your Lordship. That is the humble contention before this Honorable Moot Court of Indica. Also, Your Lordship, with regards to the first limb of my submission of third issue, global coordination and global regulatory standards are needed, Your Lordship. As stated earlier, Niti Aayog are working effectively with regards to the same, and this technology is of transcending borders, Your Lordship. And global nation must come together to be a part of it, Your Lordship. As stated, EUA Act and OECD principle, and Indica is also signatories of OECD principle, Your Lordship. So we are gaining a global consensus with regarding to the same, and we are trying to frame a global consensus for this emerging technology, Your Lordship.
You are going to frame. But what about this 2023 enactment?
No, Your Lordship. With regards to global consensus, Your Lordship, for the.
But about that you can't do that. All these member states should sit and decide.
Indeed, Your Lordship, but this,
That's an international issue.
as you stated, this is also international technology. It is not a national technology.
He is not asking for a global consensus. How can he ask? America, Australia, and Africa should join hands with you. He can't ask. He never asked you that. But you said that has not been done. All right, you are welcome to coordinate with others, but that is not the issue here.
Indeed,
the
Your
issue
Lordship.
is whether we have the law. You have said 23 Act.
Yes, indeed, Your Lordship.
23 enactment.
How-
Then about the globalization will come. You have to. That's a member state issue. United Nations, UNESCO, or some other organization has to coordinate.
Indeed, Your Lordship, as connecting with the factual matrix of the Moot Court proposition, this is a matter of international this
Yes,
is an international
of course.
technology. So it needs some global consensus with regards to the economic. If we are without global consensus, we are making it. Some companies may leave from India, which may cause a economic disruption to the country. As we have already stated, we are trying to aim and seek 1
But you
trillion.
have already done. You have already done. Therefore, some companies are going away.
Indeed, Your
Whether they
Lordship.
are going or not, you have made the law.
Yeah,
You
indeed.
have already made the law.
Indeed, Your Lordship, with certain amendment, this point will substantial, Your Lordship. Much obliged, Your Lordship. And with regards to with regard to some punishments over the stated by the Learned Brother Council, Section 66E and Section 66F of the IT Act clearly states that, with respectively, punishment for violation of privacy has already been in a penal under the IT Act, Your Lordship. And with regards to 66F, punishment for cyber terrorism, as he stated, it may lead to Al Qaeda. He has named some points, some terrorist organization. With regards to that, we have punishment for in 66F with regards to cyber terrorism, Your Lordship. Your Lordship, if Your Lordship are of no any further assistance, may I move on to my next part of my submission?
Okay.
Much obliged, Your Lordship. Your Lordship, we have already making laws, and we are in a way to make law. We are making laws and it will implement. However, in the certain time we can't implement. At the point of time we can't implement any law with regards to the emerging technologies. We need a lot of data and we need a lot of records with regards to the technicalities of AI, Your Lordship. Your Lordship, risk of fragmented policy regulation is consensus to this present matter, Your Lordship. Lordship, I may drive your attention, my kind apologies, if you may refer to flag D of the compendium presented. Flag D, Your Lordship. If your Lordship are allowing to cite a US case, it may be much obliged, Your Lordship. In the case of Chevron INC versus Natural Resources Defense Council, which is flagged as D, it has been clearly states that bureaucrat or agency are well equipped than judiciary on making policies and making interim guidelines, Your Lordship. Therefore, here pushing or urgent regulation may lead to a fragmented interim guidelines or may lead to a fragmented statutory bodies, Your Lordship. If Your Lordship are of no any further assistance, my co-counsel will continue with the third issue and much obliged, Your Lordship.
Yes, please.
May it please this honorable court, this is Moot 2 representing the respondents. If your lordships permits, may I move on to my issues?
Proceed.
Much obliged, your lordships. I am dealing with the second part of the third issue. The third issue is whether the absence of global framework must have an impact on Indica's regulation. The Council submits that without the international collaboration with the global partners, the regulations of Indica will not give the needful for the citizens of the Republic of Indica, Your Lordship. And because the respondent further submits that if the Republic of Indica has to give an effective regulatory framework, then it must build on a collaboration with the global partners, Your Lordship. And the Republic of Indica is working for that collaboration, Your Lordship. Republic of Indica is a member. Republic of Indica is a member on the Global Partnership for Artificial Intelligence, Your Lordship. They have conducted a summit on July 3 to 4, 2024 this year, Lordship, and they have passed New Delhi Declaration, which has been already submitted by my co-counsel, which states that what the partners should have followed to give a safe environment for the development of artificial intelligence and for the rights of the citizens of the partners, Your Lordship. And additional to that, there is another organization, Your Lordship, which is called OECD, Your Lordship. OECD means Organization for Economic and Cooperation Development, Your Lordship. This also has given principles what should be followed for the artificial intelligence, Your Lordship. Now, the GPAA, the Global Partnership for Artificial Intelligence, and the OECD, the Organization for Economic and Cooperation for Development, has come together and they have has a summit on December 3 to 4 this month 2024, Your Lordship, and they have yet to give the declarations, Your Lordship. Thus, the Council submits that the Republic of Indica is working together to form a collaboration with the global partners to give a regulatory mechanism that can be applicable to the citizens of Republic of Indica, Your Lordship. If this collaboration is not happening, if without the collaboration, then the Republic of Indica will give a premature and unilateral domestic regulations, Your Lordship. So, the Council for Respondent humbly submits that the issue number 3, whether the absence of global framework must have an impact on Indica's regulation, the Council submits that without the presence of global framework, there will be an impact on Indica's regulation. Thus, if court is making any law regarding to the generative artificial intelligence, then it will lead to give the will to the people of Republica, which the executive will find a burden to execute to implement the laws, Your Lordship. With this, the Council would like to move on to the next issue. If Your Lordship has no further questions. Much obliged, Your Lordships.
My point is.
Yes, Your Lordship.
Your point is the bill is premature.
Yes.
Want of global interactions.
The bill is premature, Your Lordship, because the executive is the Republic of Indica is working together to.
Then why did you the media yoga and other investigations are going on, and they are also prepared a draft enactment. What about it?
This shows that about the Niti Aayog.
Why did you made a draft enactment when the premature investigations are going on?
The Council would like to submit that according for the Niti Aayog.
I have made a draft codification.
Yes, Your Lordship.
Your draft enactment is ready.
Yes, Your Lordship.
But your argument says that it is premature. Still, some conventions should be done in the international level. Then why did you make a draft enactment without the completion of the international covenants and agreements and intelligence work?
Yes, Your Lordship. The Council would like to submit that for regulating the bodies to regulate the generative artificial intelligence present in the Republic of Indica, there is a draft has been made. This shows that there is an intention by the legislature and the executive that they want to regulate the generative artificial intelligence much further, but there are laws that is present now also, Your Lordship.
What is the basis for your draft enactment of artificial intelligence?
Based
on what basis you have prepared a draft enactment for intelligence?
Yes, Your Lordship. On basis of the proposed draft is Digital India Act 2023, Your Lordship. It's to.
What is the basis for the 23 draft enactment?
I'm
on
not.
what basis? On what basis the draft enactment of 2023 has been prepared?
Yes, Your Lordship. The Council would like to submit that there are two.
Because still the global conferences are not concluded. They are not concluded. But you have already prepared a draft enactment. What is the basis for this draft?
The council would like to submit that there are two 2023 acts related to the data protection for the citizens of Republic of Indica. One is data privacy, Digital Personal Data Protection Act 2023, which is already signed by the President. And the next one is proposed draft of Digital India Act 2023, which is about to improve the Information Technology Act further with the addition to the generative artificial intelligence to give base for the generative artificial intelligence in the main act itself, Your Lordship. That is a draft, and this is to improve the Information Technology Act itself also, Your Lordship.
Okay, proceed.
Much obliged, Your Lordships. The council would move on to the issue number 2. Issue number 2 is whether the instant case warrants judicial intervention and to what extent. The council humbly submits that the present case does not warrant the judicial intervention, Your Lordships, through the following submissions. Submission number 1, Doctrine of Separation of Powers, Your Lordship. As we know, in the Keshavananda Bharati versus Union of India, it has been said that the basic structure doctrine, basic structure should not be violated, and one of the parts in the basic structure is Doctrine of Separation of Powers, Your Lordship. To further summits about the Doctrine of Separation of Powers, the state has three part, Your Lordship. One is legislative, executive, and the judiciary, Your Lordship. The legislative will make law, executive will
How many judges delivered Keshavananda Bharati?
It's
Don't see it. I ask you. How many judges delivered judges?
Perhaps you were not born. You were not even born by then. 1973, 13 judges headed by Justice Sikri, the first direct Supreme Court. Justice Sikri, S.M. Sikri was the Chief Justice at the moment the judgment was delivered, next day he retired.
Thank you, Your Lordships. The council would
One
like
judge has written against the government. Who is the judge?
the council seeks the help of the researcher.
Okay. Can anyone tell me in this assembly, a judge acted as a president of India, who is he? Justice Siddhartha. Yes, one. How many times he has acted?
Only once.
1 month. Only a place. చేసేది మళ్ళీ ఒక్కొక్క 9 రోజులు మళ్ళీ
No idea.
Okay, wonderful. You have to gain. You have to do a lot of research. Okay, thank you.
Much obliged, Your Lordships. The council would like to move on to the arguments
Please,
that the state has three parts. One is executive, legislative, and judiciary. The legislative has a duty to make laws, and executive has a duty to execute the laws, and judiciary has a duty to interpret laws. And thus, the council would like to submit that if the judiciary is intervening in the present case, then it will leads to a violation of Doctrine of Separation of Powers, Your Lordship. But the council would like to submit another submissions also. The Doctrine of Separation of Powers is not as rigid as it can be, seen, Your Lordship, because in India, the Doctrine of Separation of Powers has a fluid nature, Your Lordship. But as we can see through the Article 13, the judiciary has power to judicial review the activities of the legislature and executive to check whether their actions are unconstitutional or arbitrary, Your Lordship. But in the present case, if the judiciary has intervened to give guidelines or to direct the legislator or executive, then it will lead to the violation of Doctrine of Separation of Powers, Your Lordship, because it will the judiciary will come to the domain of legislature, Your Lordship. With that, the council would like to move on to next submissions, Your Lordship, that as earlier stated, the judiciary has intervened and gave guidelines, Your Lordship. The cases like Vishaka versus Vishaka case, Baby Manchi case, DK Basu case, MC Mehta case, in these cases, the judiciary has intervened and has given guidelines, Your Lordship. But in these cases, but in the present case, it doesn't warrant the exceptional circumstances where the judiciary need to intervene and give guidelines, Your Lordship. Thus, the council would like to submit that the judiciary's intervention is not needed in the present case, Your Lordship. With that, the council move on to the next submission, that in the case of Divisional Manager Aravalli Golf Club versus Chandra Haas, in that case, the court has held that the judiciary must restrain and must exercise its power power in the matters within the purview of its duties, Your Lordship, and not within the matters the purview of executive or the legislative, Your Lordship. With that, the council will move on to my next submission. That is, there are enough laws present to regulate the generative artificial intelligence as of now, Your Lordship. Because the generative artificial intelligence, it's in early stage, Your Lordship. As my co-counsel has already submitted the regulations given by the Ministry of Electronics and Information Technology. It's about the due diligence by intermediaries, platforms, under the Information Technology Act and the IT Rules 2021, Your Lordship. In that, the Ministry has already given guidelines how the generative artificial intelligence platforms and the companies should perform. Like, if there is any bias, then it should not permit. And if the users have misusing the generative artificial intelligence, then it should take precautionary measures and the measures which is needed, Your Lordship.
They have taken certain precautionary measures to avoid misusing of information. Can you agree for allowing this thing?
The council would like to submit that
They are ready to take certain precautions to avoid the misuse of the information generated by artificial intelligence. Do you have any objection?
The council would like to submit that, Your Lordship, that there is
And do you have
already,
any objection or not?
Your Lordship, the laws are already present, Your
The
Lordship.
certain precautions are to be taken to avoid the misuse. They have taken, for example, assume, remember that they have made certain precautions to avoid the misuse of information generated by artificial intelligence. Now, do you have any objections to allow this case?
Yes, Your Lordship.
What is the objection?
Because the laws have already present and we have already given guidance that they have to follow, Your Lordship. So, if they are coming and saying that I can do this, so you can do this, it's not negotiable, Your Lordship. Because we have already issued directions.
They said there are not enough laws to watertight the situation. Therefore, you either pass laws to see that it is properly regulated, or give a direction by the court to the government to make laws giving certain guidelines. You do like this, and in the meanwhile, if necessary, the court may temporarily frame it. Never said that you just can't do it and we are going to do it. That's not the purport of it.
Another question for you.
Yes, Your Lordship.
Tell me for infirmities, if this appeal is allowed.
I'm not waiting out.
If I allow this appeal,
Yes, Your Lordship.
if this appeal is allowed, this case is allowed,
What will be the consequences? Four consequences.
tell me
Four
four
big-
consequences,
dangerous consequences.
that
That's what-
dangerous consequences would face the people. People will face four consequences. This is public interest litigation. This bench allows this case, the people will face the serious four consequences as a result of allowing this case. Tell me what are the four?
First one is it will give will to the people that the executive cannot enforce, Your Lordship. Next one is it will violates the basic structure doctrine, Your Lordship. Thus lead to the doctrine of separation of powers violation, Your Lordship. And another thing is it will give the people's more number of laws, Your Lordship, because we are already having a laws to regulate the generative artificial intelligence. At the earlier stage, it's enough, Your Lordship. So it will.
Court allows usage of artificial intelligence. Think for a while. Court allows all the people can use artificial intelligence. It has an authenticity. Then what are the consequences people are to be faced? Tell me four consequences. I allowed AI to use everyone. Then what consequences the people have to face?
The council.
What are the injury will be caused to the people? Now ChatGPT is no authenticity. For example, ChatGPT is there is no authenticity because there is some inaccuracy in the information generated in ChatGPT. But the Supreme Court allows all of people can use ChatGPT, they have passed an order. Now tell me, what are the 4 dangerous consequences that people will have to face?
The copyrighted will be
What
will be
copyright?
violated,
Yes,
and the lawyers and the advocates will file the false citations as your lordship as earlier stated,
Yes.
and it will affect the research. Research
Do you know
academic.
Telugu? Okay, okay. That's my point, but you have copyright. You have copy. See,
Research.
listen.
Yes, your lordship.
Copying is wrong or right?
Wrong, your lordship.
Copying good things is good. Copying good things is good. You are speaking English fluently. I copy it. It's good. Copying good thing is a good, but with permission.
Until it violates another person.
Wherever necessary.
Yes.
Copying is a good thing, but again mass copying is dangerous. It is an offense.
If you write a thesis particularly for a PhD, 60% or 70% is quotations. And now the Supreme Court also, one judge was pointing out to me, we held like this, quote. We later held like this, quote. Then quote. And therefore, we quote. That is what the Supreme Court, in some of the cases they are doing. The Supreme Court told me, this is what is going on, brother, in the Supreme Court. It not be, but to be careful. When you are, a question is posed to you, if you are asked to give an answer yes or no, you will be very careful. That's like, but in the Evidence Act, evidence we used to hear the case, have you stopped your illicit intimacy with your next door woman? Say yes or no. If he says yes, he earlier had, and now he has stopped. If he says no, he still continues. You can't give such drastic answers. Copying is bad.
Therefore, you all have to learn the difference. What is a copyright, what is trademark, and what is patent. Intellectual property rights are more carefully, but this is the era of technology. Learn to distinguish these things. Continue.
Much obliged, your lordship. The council would like to submit the report of the Ministry of Electronics and Information Technology, your lordship. The Ministry of Electronics and Information Technology has already formulated committees in relation to the artificial intelligence, your lordship, and they have formulated 4 committees, and the 4th committee's name called is Committee D, and they have submitted the report, your lordship. In the third para that has been highlighted, it has been stated that the executive is working on amending the laws which are already existed, or they are trying to create laws if the amendment is not possible, your lordship. So the council would like to submit that if there are more laws, then it will disrupt, your lordship. That's the submission. Watch
Tell
out.
me the difference between civil case and a criminal case. How you can distinguish?
Civil case, it's dispute between two private parties, and they can get
So
compensation.
government is not involved in a civil case.
It's involved, your lordship, but it's for the compensation, and the criminal is punishing. It's the crime against the state, your lordship.
What is the parameter to find out? Because of this parameter, this is a civil case. Because of this is a criminal case. How you can identify it is a pure civil, otherwise it is a pure criminal, otherwise it is both civil and criminal. How can you distinguish?
Yes, your lordship. For criminal, the council would like to submit that if that crime is against the state, it's related to the public order, and then it will come under the criminal, your lordship, and it's based on the actus rea and mens rea.
That is also criminal.
Yes, your lordship, for criminal.
But
And
how you can find out it is a pure civil case?
pure civil case, it's a dispute between 2 people, your lordship.
That is just a dispute between 2 people.
Yes, your
When
lordship.
A and B quarrel each other, and A causes grievous hurt to B, you say between 2 people it is a criminal case. How you can distinguish a civil case and criminal case?
The civil case, it's for monetary compensation, your lordship.
For compensation.
Like injunction is not a civil suit.
It's also, but I am
There is
just.
no monetary compensation in an injunction.
Declaration. How do you can
Declaration.
distinguish? First we learn what is a civil case and what is a criminal case. unless you don't know the distinction between this is a civil case and criminal case, whether it is a civil case or criminal case.
Which
Your
one?
case, now your case is whether it is a civil case or criminal case.
It's a civil case, Your Lordship.
How you don't know what is civil case, how you can say that it is a civil case?
It's for the rights, Your Lordship.
You don't know what is a civil case, but you say that it is a civil case.
The council.
How you can justify?
The council knows what is civil case, Your Lordship, but unable to formulate a sentence to
First,
communicate.
I personally, of course, I may not be accepted, but I personally always considered that the three varieties are civil, criminal, constitutional. I always consider it that way. And this case, I consider as a constitutional matter. Of course, generally, most of the constitutional matters are civil matters, including even Vishaka case. It ultimately became a constitutional issue. Therefore, I personally consider it is a constitutional. Most of the constitutional matters are civil in nature, but still they are constitutional. That's what I feel. Maybe.
What is the
maybe
ratio
we
distinct?
may not agree.
Yes. What is the ratio distinct in say Vishaka case?
Vishaka case, they have given guidelines as to follow for the sexual harassment in the workplace, Your Lordship, too. Much knowledge, Your Lordship. The council move on to the next submission. Next submission is the role of legislature and executive, Your Lordship. The council will seek Your Lordships to refer to the flag number J, Your Lordship, in the compendium. It has, in that it has been stated that the council seek 1 minute, Your Lordships. Flag number K, Your Lordship, in that it has been stated in the case of V.K. Navasa versus Home Secretary, Union of India and others, the Constitution does not permit the courts to direct and advise the executive in the matter of policy, Your Lordship. By quoting that, the council submits that the
Which year, madam? Which year is that based?
2012, Your Lordship, 2012, Your Lordship.
Court 2012. The court doesn't permit. There's a decision which says the executive matters are not to be dealt by the court, and court is not allowed. That's what the court
The
says.
Constitution does not permit the courts to direct and advise the executive in matters of policy, Your Lordship. Because in the petitioners, the appellant's prayer, they have mentioned that
Who wrote that judgment? How many judges wrote that judgment? How many judges were there in that case? 2 or 3 or more than that?
2 judges, Your Lordship.
I wholly disagree with that. Completely disagree. That's not the view of the Supreme Court also. Who were the named judges?
The judge's name, why?
There must be there. What is it?
No, Your Lordship, it has been.
You said K.
Yes, Your Lordship, it has been mentioned in the Dr. Ashwini Kumar versus Union of India case, Your Lordship.
Can anyone use ChatGPT and get up the citation? Whether we check whether we
Madam Ranjan
fake
Gogoi,
citation or the
please
correct
go to
citation.
the Ranjan Gogoi and Dinesh Maheshwari, and the third judge is Sanjeev Khanna. 3 judges, that is Ashwin Kumar.
Yes, Your Lordship,
3
for
judges.
Ashwini Kumar.
It is a 3 judges case. You go to the first page, you will see the judges' names.
They have mentioned the another case, Your Lordship. That case
You
I
have
have.
mentioned in the case, you
Yes,
have
Your
said
Lordship.
K, and I have looking at K.
Ashwini Kumar case.
Is it not Ashwini Kumar case?
It's Ashwini Kumar case, Your Lordship. They have referred to the V.K. Navasa case, Your Lordship.
I said above that judgment was in the 2 judges case was in Nawaz.
Yes, Your Lordship.
Okay.
And they have
I
referred
follow.
to this case and another case also, Your Lordship. In Ashwini Kumar case, they have referred to Supreme Court Employees Welfare Association versus Union of India and another. It has been said that Supreme Court has directed that no court can direct the legislature to enact a particular law, Your Lordship. With these two cases, the council submits that as per the petitioner's prayer, the court cannot direct the legislature to make any laws, Your Lordship. With that, the council would like to move on to next submission, Your Lordship. That for the present case, there is a need for a balanced approach regulation, and as earlier stated in the earlier issues, that the executives are working for to create a balanced law with the collaboration of the global partners to create a law which is not as rigid as it can be, to give a space for the innovation to improve the artificial intelligence, Your Lordship. With it, the council would like to move on to the prayer, Your Lordship. Your Lordship has no further questions, may I?
Please. We will interrupt you, don't bother.
Yes. Do you want to use artificial intelligence in your argument if you become a lawyer? After you becoming a lawyer,
Would you like
to use artificial intelligence for your arguments to submit before the court?
The council.
What is your personal effort? Please tell me. If you are becoming a lawyer, after you become a lawyer, do you want to use the artificial intelligence to submit arguments to the court of law?
Personal taste, your personal taste. That's what his lordship is asking you.
Yes, Your Lordship.
Yes, they are arguing against this case.
Okay, that is
Sir, Your Lordship, I am mentioning that we are working to get a regulations, Your Lordship, and the Supreme Court has formed a memorandum with the IIT Madras to get the artificial intelligence.
That is the only point here. Because it is a premature, it should not be allowed.
Yes, Your Lordship.
Otherwise, you have no objection.
We are working to give the law, Your Lordship. So the executive.
Okay, whatever you
Yes,
do.
Your Lordship.
You have only objection, therefore, still the research is going on. Therefore, this case cannot be allowed.
Yes, Your Lordship.
Otherwise, you have no objection.
Addition to that, we have already enough laws to regulate the present.
That is what I am saying. Enough law is to be regulated.
enough law is there, that's what, enough law is there, that's what she is saying.
Enough law is there.
Yes, Your Lordship.
That's what she is saying.
Then what is your objection?
My objection is they have moved before this Supreme Court.
Enough law is there, what is your objection?
Yes, Your Lordship. The council submits that the appellants has moved before the Supreme Court of the Moot Court of Indica,
Yes, I know it.
seeking interim guidelines and the judicial intervention to direct the policymakers to formulate a law, Your Lordship. We already have enough laws to regulate the present generative artificial intelligence.
But
Thus, there is no need for intervention.
Is there an authority to use ChatGPT now, as per your law?
As per my law, Your Lordship, we are.
You have said that everything is codified, enacted. Then where is the authenticity to use ChatGPT now?
Authenticity to use the ChatGPT.
According to your law, which provision authorizes me to use ChatGPT?
The council would like to create form an analogy with the ChatGPT.
See, you said that there is a complete law. I am asking where is the provision to use ChatGPT according to your research?
Yes, Your Lordship. The council says that the generative artificial intelligence is in earlier stage, Your Lordship, to regulate the
Therefore,
earlier
there is no
stage.
law.
Yes, Lordship, we have.
Do you have a law or don't you have a law? Please tell me.
We have to.
Please show.
The interim guidelines, Your Lordship. Addition to the information technology.
Pardon?
Interim.
Please show. You said that there is a law. Please show.
Madam, please see, ChatGPT is there. I am using. Is it authenticity? That the information generated by the present ChatGPT has any authenticity or not? First answer this one. I have searched for one thing in ChatGPT. It generated some information. Whether it has a legal authenticity.
For the content, the generative artificial intelligence is producing.
Yeah.
No, Your Lordship.
Then you said that there is a complete law.
Your Lordship, to regulate the generative artificial intelligence platform, we have laws, Your Lordship, to what the
Still there is
services
no
provided.
complete law. We have codified certain acts like data protection and 23 after it is still developing. Don't say that it is complete law for artificial intelligence. see there are a lot of researches are going on. Even in the USA, researches are going on. International covenants or agreements are being done. Generate a uniform code of law for authenticity of usage of artificial intelligence.
Yes, Your Lordship. But as earlier the Council has stated, the executives and legislatives are working towards to give a proper law for generative artificial intelligence, and they have already provided.
Therefore, they are seeking, make a committee. They will investigate and give you a certainty on this issue. Then what is your objection to allow this case?
The Council submits that the generative artificial intelligence has a transnational property, Your Lordship. It works within the across the borders of the countries, Your Lordship. So the collaboration is talking of the collaboration is going on, Your
Therefore, they are
Lordship.
seeking interim directions.
Yes, Your Lordship. But to regulate now, we have guidelines and we are working to give, and we are giving the additional direction in the Niti Aayog website, Your Lordship, and we have already formed 4 committees on the generative artificial intelligence, Your Lordship.
Oh, therefore, there is no need to pass other guidelines than you have already.
We are working and we are giving directions. The company should
You are
follow.
onto it, that's what you say, you
Yes.
are onto it already.
Yes.
Committees are examining this issue.
Yes,
That's what
Your
you say.
Lordship.
Therefore,
And-
there is no need of giving any additional interim directions.
Yes, Your Lordship. And the Council would like to submit that if a matter is already pending consideration and debate with the executive or parliament, then if any directions or the judiciary is going to give, then it should be with a great care and circumspection. And if a court direction is it's not needed if there is a consideration before the executive or legislature, Your Lordship. With that, the Council would like to move on to the prayer, Lordships.
Yes.
Much obliged, Your Lordship.
Yes.
Wherefore, in the light of the issues raised, arguments advanced, authorities cited, it is prayed before this honorable court that it may be pleased to dismiss the appeal filed by the appellants and pass cause to the appellants and give any other relief that this honorable court may deem fit in the interest of
Yes.
justice, equity, fairness and good conscience, which are respectfully submitted. Much obliged, Your Lordships.
Provision for reply. There is a provision for reply. Yes.
The Council seeks permission for much of it. We also, with respect to the first issue, that is with respect to public interest matters.
Yes.
Apologies, Your Lordship. Permission.
Take your vote.
Each team gets 5 minutes for rebuttals.
Your Lordship,
But where is the point in rebuttal for the other side? They have argued in reply. But where is the point in rebuttal for them again? Rebuttal, then again rebuttal. If that is so, he will argue, he will now rebut, again they will rebut, again he will rebut.
There is
Where
a
is
end.
the point in
There is a end.
the method is argument, counter argument and reply. That is the end of the matter. That's what, of course. You permit go on, all right, whatever you want to argue is a different issue. But otherwise, they have argued, they have replied, then they will say, no, this is not correct. That's another matter.
That is the reason we have limited the time for 5 minutes for rebuttals.
But forget about the time. They submitted a case. They also submitted.
All right, let them give. All right,
No, he is giving
please,
reply.
please come on,
Whatever
come on.
you want.
Whatever you want to say. And again, whatever they want to say, they will come on.
They will be provided with the rebuttals. Yeah, it's
See, what is the point, madam? What is the point? They will rebut. This again they will rebut. No, they want, again they will rebut.
Based on the content, Your Lordship, based on the contentions made by the respondent.
They are rebutting. Yes, they are rebutting.
On their rebuttals,
Ah.
they will.
There is a point.
That's not at least according to law. That is not legal.
See, because why?
Madam, I was a judge for 34 years. I never heard this sort of a situation. Rebuttal.
See, only reply. There is no another of the reason. First they have submitted their case. They had. Listen, they had. Therefore, reply includes in their argument because they have. But why we are giving reply time to him? He did not hear their case. Therefore, while submitting their argument, because of their hearing of his case, they can reply in their argument itself. Therefore, they cannot get again reply.
No, but theoretically, they want to distribute the points. All right, we will permit. We will permit anyway. Come on. All right, this one, we will permit. Please go ahead.
Your Lordship, with respect to the first issue, they contended that the appellants hearing don't have public interest in the issue, and also that appellants do not have locus standi. Your Lordship, I would say that a technology which deals with impersonation, which deals with deepfake, which deals with inciting public, which deals with various societal aspects that are involved in our society, this definitely falls within the definition of public interest, Your Lordship. Public definitely do have interest in it. And also, the Learned Counsel for the Respondents used the word publicity and advertisement. Your Lordship, herein it must be noted that it was not substantiated, and also the NGO is initiated by altruistic scientists, Your Lordship. They do not work in the field of advertisement. They work in the field of knowledge. They work in the field of research, Your Lordship. And also, Your Lordship, the word altruistic, as I mentioned earlier, since it is the only word that is being provided to us in the fact sheet, it clearly shows that they think about the society even if it is at the cost of theirs. And also regarding the submission that I made regarding the freedom enjoyed by scientists, Your Lordship, scientists do not necessarily enjoy restrictions. If scientists are approaching the Honorable Court and seeking some sort of restrictions and regulations, that inherently shows that there is public interest involved in the matter, Your Lordship. And Your Lordship, regarding the Digital India Act, Your Lordship, Digital India Act 2023 that was raised by the respondents. Your Lordship, that act, if my memory serves right, that is just a slideshow of sorts, Your Lordship. The one that is being submitted to the Honorable Court, there is nothing concrete in that particular act. There is no bill regarding that. The Digital India Act is a proposed act that was supposed to happen, and there were some discussions going on before 2-3 years. However, it has been on a standstill ever since, Your Lordship. And also regarding Digital India Act, there is no focus on generative AI in particular, Your Lordship. When we talk about generative AI, as I mentioned in my arguments, it is a disruptive technology that comes once in a century, Your Lordship. If you follow the trajectory of artificial intelligence development, it has been there since 1950s. However, what happens is periodically there comes a breakthrough development. Generative AI is one such breakthrough development which has several ramifications. So what we are saying is that a generic law cannot address the concerns, as again and again were highlighted that IT Act and all the other acts can provide a remedy for any sort of grievances that could arise due to generative AI. However, we are contending that since this is a very special and specific nature technology, this requires a special focus and recognition and understanding of the technology and then addressing it, Your Lordship. Now, Your Lordship, the Learned Counsel for the Respondents also said that they have issued some sort of guidelines from the Ministry of Electronics and Information Technology. Your Lordship, these were not guidelines. Instead, these were clearly titled as advisories. Here, every word, I may submit this to the Honorable Bench, Your Lordship. One advisory was issued on 1st of March 2024 and another advisory was issued immediately on 15th of March 2024. Your Lordship, in that span of 14 days, what happened was, in the initial advisory, they stated that all the intermediaries and platforms are to follow certain things that are mentioned in the IT Act. Immediately after that, there was a backlash from the startup community and the artificial intelligence technology community, and the Minister of Information and Information Technology came up with a statement that this is applicable only to the big tech giants and not to the startups or any sort of other companies. Your Lordship, and also if you could peruse the kind of wordings that are used in that particular advisory, Your Lordship, it just says it is advised that you follow this. And also, Your Lordship, there is no enforceability to that particular guideline. And also, if you look at just a minute, Your Lordship. Your Lordship, if you clearly, it is clearly seen that every intermediary or platform here, the generative AI has two aspects. One is the developer aspect, another is user aspect. Here everything is addressing with respect to user. That is, if I commit an offense using this particular tool, then what is the remedy that is being provided to me by the existing act? However, there is no liability fixing mechanism based on developer. There is no liability fixing mechanism based on the risk level associated with it. Now, if you observe the corresponding EU AI Act, which is enacted in the European Union, Your Lordship, there they clearly highlight that these are the liability that could impose on user who is using it. These are the liability that we can impose on the developer who is developing such things. Your Lordship, developing a particular generative AI model and putting it on it, like basically making it available to the users on internet. Your Lordship, that definitely there is a sense of liability that must be attached to a developer as well if he is developing that particular mechanism just for that use, Your Lordship. If there's a platform that allows you to, Your Lordship, I conclude my rebuttal by saying that if there is a platform, then the liability should be fixed both on user as well as the developer, and hence there is a need for clarity, and in that clarity the court can intervene and issue interim guideline or issue a directive in this particular matter, Your Lordship. It was a pleasure being here. Much obliged.
All you four presented well. Don't think about the result. Always cultivate the habit of participating in the competition. Whether you win or lose. Don't think about the result. Always go on doing efforts. Law profession, like money is, my lordship, all you will say, money is not right. Your passion is different. Your guidance.
The council seek permission to give rebuttal, Your Lordship. The first submission is the present appeal. As present appeal is about whether pill is maintainable or not, the earlier pill is maintainable or not. The council submits that there is no violation and pill is not bona fide and there is no substantial question of law, Your Lordship. Let the council move on to the next submission, Your Lordship. Next submission is my co-counsel has already submitted the DPDP Act, the Data Protection, Digital Personal Data Protection Act, Your Lordship. It is presented, it's printout of a gazette copy, Your Lordship. So this shows that it has already been signed by the President, Your Lordship, and the council has already given the date also, Your Lordship. It also mentioned in the Act itself, Your Lordship, 11th August 2023, Your Lordship. With that, the council move on to the next issue, Your Lordship. The opposite councils has mentioned that we have submitted different guidelines and all, Your Lordship, but we have submitted the same guidance, Your Lordship. It's dated 15 March 2024, Your Lordship. In the second page itself, it has been stated that in the 4th and 5th clause, it is reiterated that not compliance with the provisions of IT Act and our IT rules could result in the consequences. It's not, but not limited to the prosecution. And the intermediaries are hereby to ensure the compliance with the above with immediate effect, Your Lordship. This shows that this is not just a guidance, Your Lordship. This should be followed, and if not, it will be prosecuted under the IT Act and other criminals Act, Your Lordship.
The European Council or somebody, well, it has already made some laws. You say international ramification, it has to be done. One country has already done. What's the problem for it?
Yes, Your Lordship. And the council would like to differentiate that they are developed country, Your Lordship, and we are developing a country.
We will always be developing country. Take another 100 years. From the time of Nehru without even a pin, he had to start. Even now, we are a developing country only. We are never a developed country. Therefore, we have our own laws disregarding the laws of the other countries, and we say that we have a trillion million GDP and all that, and you still call it a developing country. Or is it a developed country? I don't know. If you say that it is still a developing country, well, we don't require all these things. First of all, we require food and education.
Your Lordship, we are trying to create a balance, Your Lordship, between the investors and the companies who are giving the generative.
That's exactly what he is pointing out. The investor, the person who is generating, he must also be taken to task. That's what he has suggested, isn't it?
Yes, Your Lordship. In the guidelines itself, they are regulated, Your Lordship.
About the investor's liability.
Not about the investors, Your Lordship, the platform, the one who is
The
giving the
platform.
generative artificial intelligence, Your Lordship.
The liability of the person who is supplying the information.
Your Lordship, under the DPDP Act, there are three persons, Your Lordship. That is one data fiduciary, data principal, and the data processor, Your Lordship. The one who gives data. One who gives data is called data principal, and the one who uses the data is data fiduciary, Your Lordship. And the data fiduciary is responsible if there is any violations, if there are any infringement from the infringement on the data, Your Lordship. So
The person who gives the input is not answerable. The person who uses it is answerable.
Your Lordship, how they are using, if the company is giving if the violation, if there is any failure on the part of the company, then the company will be liable, Your Lordship. And if the user is misusing the generative artificial intelligence, then the user will be liable.
Give an example of the user misusing it, like you say, perhaps as His Lordship has pointed out, the wrong citations. Perhaps that's if you say that is an example, but what can you do? The wrong citations are given. Then depending upon that, what about the person who gave the wrong citation, first of all? What about the punishment to him? That you are not talking about.
Yes, Your Lordship, but it only regulates the criminal activities of the person who is using the general
the criminal activity of the person actually who is responsible for it, he is safe, isn't it?
Your Lordship,
that's all what you are saying.
I am not getting your point, Your Lordship.
See, the person who actually gives the input,
yes,
he is safe. He is safe. No punishment, nothing, you can't touch him. The person who is using that input is punishable. That's what you are saying, isn't it?
No, Your Lordship, it differs from one circumstance to
What?
other
Please tell me.
circumstance, Your Lordship.
Please tell me a couple of circumstances where the input man is safe and he is not safe. Please tell me.
Where the company is not safe.
Some input is given, isn't it?
Yes, sir.
Somebody say Australia, Brisbane. What are the roads in Brisbane? Some information is given. The person who has given the information, he is not answerable. Is he answerable?
Is there
Under
no
what?
accountability for him? That's possible.
Yes, Your Lordship. The Council would like to submit that the generative artificial intelligence has its own intelligence. So, if there is any part on the designing part, if the inputs are given by the mistake of designing part, then the company will be liable, Your
Which
Lordship.
company?
The one who gives the platform, Your Lordship.
The person who suggests the inputs, who gives the inputs is also liable.
If it's a, Your Lordship, the Council would like to create an analogy with the Instagram or Facebook, Your Lordship. If someone is misusing the platform, Instagram or Facebook, then the person who is misusing will be liable, Your Lordship.
That's not what I am asking. That you already said it.
Yes, Your Lordship.
What about the person who has created that Instagram?
Yes, Your Lordship. If they are getting the information from the users, if they are there is a violation of data privacy, then the company will be liable, Your Lordship. And if the giving of wrongful answers, the generative artificial intelligence are in its emerging stage, Your Lordship. Even now, the ChatGPT developers have released the new version of ChatGPT, Your Lordship. So this shows that it's getting emerging, Your Lordship. So the answers can be they might give new answers, they might give different answers or correct answers, Your Lordship. And the Council submits the generative artificial intelligence runs through a data, Your Lordship. Only if we give the correct data, then only it can give the proper answer, Your Lordship. If we want the proper citations for a case law, then it should be collaborated with the proper like SEC online, then only it can get the data from there.
So
and use it,
anything
Your
that is there in the artificial intelligence cannot be accepted. Nothing can be accepted. It has to be further checked. Then what is the purpose of that artificial intelligence at all? Why do we need artificial intelligence? You said that any data is to be checked with the SEC online. Same thing with everything. Doctor, medicine is prescribed. Artificial intelligence gives, no, you have to check with some doctor or some pathologist. What for is that artificial intelligence? I don't understand.
The Council submits that it's emerging, Your Lordship, and it's.
Therefore, you don't want to give any punishment to the person who is giving the input, who is saying, if this is the disease, this is the solution, or this is the medicine.
You are not punishing. A person, a doctor who sees it, oh, this is the treatment that is to be given, he prescribes, he is punished.
Your Lordship, the generative artificial intelligence platform has also have punishments like penalties, Your Lordship.
For whom?
For whom?
For the doctor who is using it. I am not asking. For the, see, somebody is suffering from cancer. If somebody is suffering from cancer, this is the type of cancer. This is the sort of medicine or treatment that is to be used, that is given in the article. Somebody fed it. Somebody fed that information. Is he not answerable? Is he not punishable? No. No, according to you, he is not punishable. You can't touch him. The doctor who sees this and uses it on a patient is punishable. That's what you are saying. If that is so, it is most unfair.
The council would like to submit that I have already submitted a page on the report of the committee which says that we are trying to finalize the liability.
Exactly what I am
part,
saying
Your
here.
Lordship.
That's, I think you know Tamil, Parkala. How can it be, madam?
No, Your Lordship.
Parkala means we will see later.
Your Lordship, if the council would like to, no, Your Lordship, the council would like to rest the case here. Much obliged, Your Lordship.
Right. Why should we go to Tamba? Why should we sit here? We will go there. మేము పోతామమ్మా బయటికి ముందు అది వెళ్ళిపోతారు మనం కొంచెం చుట్టూ పట్టుకుంటాం
The participants and the audience are requested to move out.
Participants, do you want to have any question? We have a meeting, we will discuss. Other things we will see.